just in case there's anybody who has any doubt, my Lord, I want to say it here in public, that for the purposes of this court and the purposes of this application, this court has no option but to take that judgment as granted. Even if your Lordship read the judgment and said, I've never seen any judgment so bad, there's nothing you can do about it, there's nothing I can do about it, and there's nothing anyone can do about it.
So just on that point, can we clear up an ambiguity in the papers about the effect of the application for leave to appeal?
Yes, my Lord.
Is it your case that the filing of your application for leave to appeal suspended the operation?
Yes.
Of the order?
It is, my Lord.
Yeah.
And let me explain and how it fits into...
So while I must accept that it's a fact,
yes,
what you urge me to accept, that the order was final in effect,
yes,
and the filing of the application for leave to appeal suspended.
yes, that's correct.
And the irrationality you impute to the JSC is that it just didn't appreciate.
Didn't recognize that fact, among other things. My Lord, your Lordship is making my job much easier. Let's go there, because that's the third interpretation point, as it were. I'll deal with it very quickly. What we're saying, my Lord, and this is again, I've dealt with this Section 18 things many times at different levels, and there are always these common problems around it. Remember, the difference between us and the respondents is that this is an 18.2 event, and we say it's an 18.1 event,
yeah,
as your Lordship just summed it up.
Yeah.
Now, these are the simple reasons we say it's an 18.1 event, my Lord, is your Lordship will find the actual wording of the, of the sections in our notice of motion and our founding of the, I think it's 02-60 something.
Yes, I have the act in front of me. You don't need
Oh,
to.
perfect. Okay, fine. Let me also just rather do that here. So let's start at 18.2, my Lord, and just read it together. So 18.2 says, subject. Okay, the two things define whatever the default position is.
Yeah.
Subject to subsection 3, unless the court under exceptional circumstances orders otherwise, the operation and execution of a decision that is an interlocutory order, not having the effect of a final judgment, which is the subject of an application for leave to appeal, is not suspended and pending the decision of the application or appeal. Now, all we're saying, my Lord, we accept, we concede that when we wrote the letter on Monday, this Monday, the applications for leave to appeal were not in. But we obviously indicated that they're coming, and as soon as they came, we sent them. In fact, I think, if I'm correct, subject to correction, by the time the JSC had its meeting, we had already lodged.
Yes, well, in its letter, the JSC refers to Section 18.2.
Yes.
And so I think...
So they must have, yes.
I think they must have
yes,
appreciated that either their decision had to be taken on the basis that the appeal would definitely come, or that it had already come.
Absolutely.
Yeah.
As the court pleases, my Lord. And I want to kill two birds with one stone, as we discuss this, my Lord. The first bird is to answer your Lordship's question as to why we're saying it's an 18.1, 18.2. The second one comes from what your Lordship's remarks just now, which is why we assail the JSC decision on this point. In other words, we're saying on this point they made a material error of law. And as your Lordship knows, material error of law leads to irrationality or illegality.
Well, if they made an error that's as basic as you say they did,
yes,
then that definitely renders their decision
yes,
irrational.
Absolutely.
There might be some highly complicated
explanation
terrain in which an error of law doesn't lead to irrationality, absolutely, but I can accept for the purposes of this case it does.
Yes,
yeah,
absolutely.
If there is such an error.
Yes, if a big if. Yes. Thank you, Madam. Now, so since we're on the same page on that, my Lord, let me then explain this in simple terms. So we say there are two exceptions which are contained in 18.2 that assists us in our interpretation.
Yeah.
The first is the word interlocutory order. A decision that is an interlocutory order.
Yeah.
Many people read that to mean an interim order. But that's not the same thing, because as your Lordship knows, there are interim orders and there are interim orders. And that has been explained in a case that I did called Libashe, that everyone knows. I think it's the most recent.
The section itself appreciates that there may be interlocutory orders of final effect, because it only applies in circumstances where there's an interlocutory order not having the effect of a final effect.
Yes, and that's the second point.
Yeah.
So we're saying, my Lord, forget about the final effect for a minute.
Yeah.
If it's not an interlocutory order, even if it had or didn't have final effect, that would favor us. But secondly, as your Lordship correct, let's assume we're wrong on the interlocutory order thing. If it has final effect, then it's excluded as well. Now, so we say on both legs, my Lord, that favors us. And every lawyer, and I'm sure my learned friends will be no exception, will accept that if there's an application for leave to appeal and you can discount 18.2, then by default, then it's, you are in 18.1.
Yeah.
So that's our argument. So our argument is simply this, my Lord, that because of the operation of those two exceptions, we're in the 18.1 land. And once we're in the 18.1 land, contrary to what all our learned friends are saying, no, why, even on alternative relief, why don't you go to 18.3? No, it's them who should go to 18.3. They are the ones who have a duty, if they don't want to the order to be suspended, to do an 18.3 application. Thank you, my Lord. I'm not going to belabor that point anymore. The court. Yeah. I'm not saying the court agrees with me. It understands.
I have the point.
Yes.
Thank you.
Thank you, my Lord. So that's a huge interpretational point on the one hand, but secondly, an attack on the reasoning process of the JSC. So I want to do it one by one. Now, my Lord, if your Lordship allows me to then, I'll do another double take to demonstrate to your Lordship that what we are talking about, while accepting for the purpose of this, that what your Lordship correctly called the fact of that order, that we accept. But what this case is all about is about the constitutional effect or the constitutional impact of that order. We're not attacking the order. We're simply saying its constitutional impact results in the JSC as matters currently stand being improperly constituted. That's really all. It's that simple.
And that's the second basis on which you attach the JSC's decision.
Absolutely.
JSC ought to have appreciated that it would be improperly constituted if it proceeded.
Yes, and if you look at their letter, my Lord, you will see that actually is the main material error of law, as it were. For them, the main.
They essentially say you're still Dr. Klopper is still a member of the JSC.
So what's the problem?
He just can't come.
Exactly. Yeah. Well, that's what they're saying. Whereas, in reality, my Lord, if we are correct on this point of the constitutional impact, and let me, if your Lordship forgives me, let me just quickly get rid of no, I'll deal with it when we deal with the exclusion.
Yes.
Let me stick to the constitutional impact. So if the constitutional impact of that valid order of the Western Cape High Court is to create an unconstitutional situation, a situation that is inconsistent with the Constitution. If I succeed in persuading your Lordship that the situation created is inconsistent with the Constitution, then your Lordship has no option, because Section 172(1)A says you must. Once I can show that constitutional inconsistency, your Lordship must declare that conduct to be unconstitutional.
Well, we get to the same result if I concluded that the JSC had acted irrationally.
Yes. No. Actually, my Lord,
that would be in breach of Section 1C.
Absolutely. In fact, my Lord, and I'm glad your Lordship asked that question, because again, it's misunderstood. That's the difference between Section 38 of the Constitution and 172. The Lordship has hit the nail on the head. Some people confuse the two. Section 38 deals with an infringement or threatened violation of a right in the Bill of Rights, right? But Section 172(1)(a), as your Lordship has correctly summed up, deals with the inconsistency with the Constitution, not just with the Bill of Rights. So any section of the, so that's the difference which is usually misunderstood. And your Lordship is 100% right, whether it's Section 1C or Section 200 or Section 300 or whatever. If you are able to I know, I know there isn't.
Yeah.
Yes. No, Lordship is definitely on point. But I'm exaggerating for effect.
Yes.
So I'm saying, my Lord, whatever section of the Constitution is violated, or once that is established, of course, that's the gateway. Once that is established, then and the constitutional writers, my Lord, were it was a deliberate way to phrase 172(1)(a) as opposed to 172(1)(b, because that's what constitutional supremacy is. We can't say the Constitution is supreme, and then we say a court has a discretion.
Well, it seems to me the 172 duty is to declare any conduct that is inconsistent with the Constitution to be so.
Absolutely.
But then there's a wide remedial discussion about what a court does.
What to do, yes. Yeah. In fact, sometimes the court may do nothing. but what a court is enjoined to do constitutionally, it's a duty, a constitutional duty, is once established, it must declare. Yeah. And that has been said, my Lord, if you, Your Lordship, allow me 1 minute to digress as to why that is so. One is constitutional supremacy. We've dealt with that. Yeah. But the second one, which is always forgotten, is something called the doctrine of objective constitutionality. Now, that's just a lot of big English. But what it really means, my Lord, is that when the court does that and makes that declaration, it is not declaring the conduct of the JSC to have been unconstitutional last week or on Tuesday when it had a meeting. It's declaring that that conduct is unconstitutional since 1996. Yeah. That's so it's...
And that's the retrospectivity is...
Absolutely, yes. That's why sometimes the court then ameliorates that, yes. So it is that serious. That's why we have something, my Lord, another misunderstood concept called the Gijima principle. And it goes like this. Once a court has a 172(1)(a) issue in front of it, it must, even in the face of unreasonable delay, in the face of mootness, and all these other niceties, that court, according to the Gijima principle, still has to grant the order. Why? Because all these niceties notwithstanding, a court cannot go back to chambers to put it, to demonstrate it, and leave an unconstitutionality sitting on the table, simply because it took me 6 months or whatever. It's that serious, because that implicates the supremacy of the Constitution. Now, that then puts a burden on me, my Lord, to convince Your Lordship that there is indeed an inconsistency with the Constitution. Not in the full court, in the conduct of the JSC, yes.
So the two points you've made so far are that the JSC misconstrued the effect of the order.
Absolutely.
And that it misconstrued the impact
of Section 18.
Of excluding Dr. Hlophe from the proceedings.
Yes.
Is there any further point?
Yes, and Section 18, you remember we just discussed.
But doesn't that really collapse back into final or interlocutory effect of the order? If the JSC thought that the order was interlocutory in effect when it was only final, when it was actually final in effect, it doesn't. The issue about whether 18.2 or 18.1 or 18.3 apply falls into that misconception, doesn't it? No, my Lord, with the greatest respect. If it's much more serious than that. It is that, of course, but it's more serious than that. It has two serious impacts. It says that the JSC, when it was given, remember the JSC is an organ of state. So it's the better way to put it, sorry to interrupt you, but the better way to put it is your case is that the JSC failed to appreciate that the order was suspended by the application.
Absolutely. And in doing so, as we discussed earlier, committed a material error of law.
Yeah.
And if the JSC's decision is irrational, then the Lordship has no option.
Yeah.
But to.
And then there's the constitutional impact of proceeding in Dr. Hlophe's absence. Is there anything else that in your submission vitiated the rationality of the JSC's decision?
Yes.
Yeah.
Yes, my lord. Okay. Let me put it this way, my lord. If your Lordship allows me, I won't answer the question directly. I just want to start at the end. One of the giveaways, and we say this, unfortunately, your Lordship hasn't seen our reply, but your Lordship will find in our reply that one of the things we say is that one of the giveaways that the JSC's decision was irrational is something that is said by one of its commissioners, Mr. Nkaitobi, in his supporting affidavit.
Yes.
In that, he actually says, my lord, your Lordship will find that in section 6, page. Anyway, my lord, let me paraphrase to save time. Your Lordship will take your Lordship there. But this is what
I have it here. It's 06-287.
287.
Yeah.
Yes, my lord. All right, I'll get to it. Let me just paraphrase. Your Lordship will read it in well, there's no good time. I was going to say in good time, unfortunately.
No, but I have already read it.
Yes.
So if you just advert to the part of it, just while we're on this point, I still don't see the replying affidavit on case lines. If someone on your team could sort that out.
Yes, my attorney is here.
Yeah.
Can you just reload it? That's please.
Thank you. And if you can't sort it out for any reason, just email us.
We'll give you a hard copy. In due course.
Yeah.
Now, there's your Lordship, again, I won't bore you with all these authorities. Your Lordship will know there are cases, the line of authorities, National Lotteries Board, there's a case of Zuma versus the DA and so on. It's all in our heads. Yeah. But the gist of those cases, my lord, is this. The first one was Kachalia JA, I think the second one was Wallis JA, and the other one is NAFSA ADJP. And they all say this paraphrased. When you give, and we're now, my lord, busy really scrutinizing the letter of reasons that is given by the JSC. And I'll show your Lordship that that letter is not worth the paper it's written on. We've dealt with the Section 18 thing. Now, in this phase, my lord, that line of cases says, makes the following simple proposition. If I do something, and then my learned friend, I'm an organ of state, says, why did you do the something? And give me reasons. Then I give her reasons A, B, C. Then she challenges
This is the reasons that you gave at the time. That
absolutely.
You can't supplement your reasons.
You can't, and in the answering affidavit. Yes, that's the principle.
Yeah.
So what Justice Kachalia called the ex post facto rationalization in the answering affidavit must just be chucked out. It doesn't count. Yes, your Lordship got the point.
Yeah.
So, contrary to that noble principle, the JSC tells us that no, after we gave you the reasons, we then went and did some research, and Mr. Ngatobi says, I then went and spoke to each division and what have you, and then they give us a litany of reasons why the order should not be
well, aren't they just trying to talk about the balance of convenience?
Yes, no, I know, my lord.
I'm not sure they were being proffered as considerations that were present to the JSC's mind when it took the decision not to postpone.
No, my lord.
What they're saying is the balance of convenience doesn't favour you.
I appreciate that, but well, then that's even worse, because if that is so, then again, it's that thing of elevating the alternative. Then we must check it out for that reason, because it's got nothing to do with the real case, which is the declarative.
Right.
Right. If and only if we ever get to the alternative relief, then all that might be relevant. So otherwise, all that is just completely.
But I certainly,
and I appreciate
you can certainly take it from me for the purposes of your argument, but I don't, in order to consider whether the JSC's decision was rational, it would be a mistake to ascribe the facts given in Mr. Nukai Toby's supporting affidavit to the people who made the decision, or to say that to find as a fact that all of this was present to their mind at the time they made the decision.
That's a hallelujah.
Well, what was present to their mind is what they told you.
Absolutely. No, then we're fine, my lord.
In their letter.
Yes. No. Then we're done on that one. I promise you, I won't even breathe a word about it. Yeah. So if we then go back to the letter, you'll find that, my lord, irrespective of the, lawyers can dissect these things, but really there's one reason in that letter, and it is that the JS, or rather, the full court did not kick Dr. Hlophe out. That then takes us, my lord, to the cases, to the authorities. The authorities.
Yes. So sorry. Just to sum up, so I know where you're going.
Yes, my lord.
On the basis that the question of the rationality of the JSC's decision must be determined by assessing the reasons they give in the letter.
Yeah.
You really only want me to find that paragraphs 2.1 and 2.2 of the letter are just wrong, and that renders the decision irrational.
Absolutely,
yep.
And not, as your lordship knows, and I don't want my learned friends to think, and I know your lordship that's not what your lordship means, but when we say wrong in this sense, we don't mean in the appeal sense.
No, there's
we
been
mean
a
material error of law. Yes.
There's been a misconception of a basic.
Absolutely.
Your case is that there's been a misconception of a basic factual or legal proposition that has tainted the rationality of the JSC's decision, and the two respects in which you say there's a misconception are essentially spelled out in 2.1 and 2.2 of the letter.
And the preamble, my lord, that's where they talk about section 18.
Yes.
Which we have covered. Yeah.
Yes,
so
okay.
if you want to be generous, my lord, we say there are three reasons they've given. It's the 18 2 reason.
Yeah.
The second one is the non-setting aside of Dr. Hlophe's membership. And then the third one is really the same as the second one, where they say the full court has interdicted from participating in the process. It's expressly found that Dr. Hlophe's absence would not render the JSC's decision operational. That's just wrong. That one is wrong in the true sense. Let me tell you why, my lord. Because your lordship knows that at paragraph 56, I think, of the judgment, that last one is just, it should take 1 second to deal with it. Yes, it's paragraph 56, 02-66. What the JSC, I won't ascribe any deliberate intent to it. Let's say it's a material mistake here. They said the court there said the respondent's submission that the JSC would not have a quorum in order to take a valid decision if Dr. Hlophe is interdicted from participating in that forum is incorrect. Well, I can tell you, my lord, for free that we never made that submission, but that's not for you, that's for the appeal court. Yeah. But assume for now, for present purpose, that we did. The court then goes on to say that in the premier case, the issue was whether the premier's attendance was necessary, and the court concluded that it was, which is correct, by the way, and we rely on that very heavily.
Yes.
Yeah. Now, the mistake that everybody makes is to conflate two simple things that are not the same: quorum and constitution or composition. We accept, again, for the avoidance of any doubt, if anybody wants to accuse us of saying the absence of Dr. Hlophe is going to affect the quorum of the JSC, well, I'm saying here loud and clear, no. We accept implicitly that the quorum will not be affected. What is affected is the proper constitution of the body in our respectful submission. Yes. That's all. And those are two unrelated things. So again, when the JSC then says in its 2.2, my lord, that the High Court found that it doesn't matter. Well, you can just scratch out 2.2 because we agree, but that cannot be a reason to deal with what we are raising, which is the composition. Yeah. So that's why I say in reality we're really left with 2.1. Now, my lord, let me just make another point, which whatever I do, I must not forget. And this deals now with what I was saying are the authorities. Yeah. And now on the second leg, the interpretation points I've dealt with all, my lord. On the second leg, which is what we call unjustified exclusion. Yeah. This is the case of the other side, and I'll show you how fallacious it is. They say, and you can see how clever lawyering constructs this argument. So they say, yes, we accept that in the SCA has twice said in Premier and in Bar Council that the composition of the JSC is all and for one. Everyone must participate in the decision. They say we even accept that principle comes from the old cases Ski Road and so on, and the lex impossibilia principle and so on and so on. But they say, but the problem is that MK and Dr. Hlophe have forgotten one thing, which is that that court made the qualification that it must be an unjustified exclusion. And then they say, how can it be an unjustified exclusion? Because there's a court order. Very attractive argument at face value, but it is absolutely wrong. You see, this court is bound by the SCA decisions. And to the extent that the SCA, even if there was some discrepancy between the SCA decision and the full court decision, this court would obviously be bound by the SCA decisions. Yes. So I'll concentrate on them. What was said, my lord, in both cases completely assists our case, my lord, and shows that the JSC's reasoning was completely flawed. What was said in the let's start with the Premier case. There, my lord, Helen Zille, who now has flip-flopped and taking a different stance in her affidavit, was saying that the JSC was not properly constituted because she was not in the meeting in terms of I think it's 1K. Yeah. And she then said, well, for that reason, because firstly I was not there as the Premier, but also my alternate was not there. Therefore, the meeting was not properly constituted. And the SCA, for good reasons, agreed with her. And but now she wants the other side of the coin. The SCA agreed with her on the following basis, my lord. The case, and I must concede this, is not on all fours in the following respect, my lord. The gravamen of that discussion was about 178.6, as your lordship knows, the majority or no majority. But in the course of that, the court did two things. It reaffirmed the principle, and that's why Ms. Zille won the case. It reaffirmed the principle that everyone must be there. But it also left open a very important question. You'll remember, I think it's paragraph 21 of that judgment, my lord. Yeah. It was raised by, or rather the court accord, Jones J, had also made Ms. Zille to win the case on another aspect. And that aspect was this. Ms. Zille had raised the following point. She said, one of the advocates that are in 1E had not yet been appointed, and therefore the body was not properly constituted, and she was right, of course. Again, nothing to do with the quorum, but the constitution. And the court said, because we have already found that she's right on the primary ground, we're going to leave open the second one. So which means, as we speak, that finding of Jones J, that even on the second leg, she was supposed to win, stands. Or at least it was not overturned by the SCA. I can't put it higher than that. Now, so what does that do, my lord? Two things. One, we must remember that our case is stronger. I'll tell you why it's stronger than both the Bar Council case and the Premier case. In both of those cases, my lord, the so-called absent member of the JSC was somebody who was allowed to have an alternate. In this case, there's no such, and that's the kind of thing Mr. Ngalwana was alluding to. The delegation, the delegation of 6 in 178(1)H must be as it is. It's a half a dozen, or it's all or nothing. They are not allowed to even have alternates, unlike all these other people. The judge, the chief judge, even the judge president and the premier and so on, those people are allowed to have alternates.
Yeah.
But here, it's you have to attend personally, or you must not be there. So that's a crucial distinction, which makes this particular case distinguishable in the positive sense, in that it's even...
Notionally, the National Assembly could elect someone else, but then they'd be reconstituting
Absolutely.
the JSC.
The entire squad.
They wouldn't be giving Dr. Thorpe an alternative.
Absolutely.
Yeah.
Absolutely, my lord. Your lordship, that gets rid of something else I was going to say about alternates. In other words, even this, there's this thing that gets bandied about, oh, what's the problem? MK could simply substitute Dr. Thorpe and put somebody else. No. How? Under what basis? On which constitutional basis? There is no such constitutional basis. The lordship is correct. The only way you could ever achieve that would be to take the entire resolution back to the National Assembly and then have a new delegation, which may or may not include Dr. Thorpe and all that. And that's why in our letter we said, even if we don't accept that that can be done.
I think it's common ground that the National Assembly would have to hold the election again if it wanted to replace it.
Yes, no. But it's not. No, it's not, my lord. All these parties are saying they don't know what we are complaining about, because MK can simply somewhere put somebody else. But your lordship is quite correct. The only way you could do that is to revoke the designation. And that's another facility that is used by FUL in particular. They suddenly now sometimes you surreptitiously do something. Suddenly they talk about designations. There's no designations. It's a designation of it. So that designation would have to be redone. And that, my lord, to be quite honest, was all we were asking from the JSC. We're saying, even we don't agree that you can substitute, but for the present purposes, say you can. We say to them, the Parliament is in recess. The thing is starting on Monday, and even if that thing that substitution was allowable, it can't practically be done. So please postpone, and I'll even be more strict. I'll be much stricter than Mr. Ngalwana. 6 months. 3 months, 2 months, whatever it is. You could even say, okay, we'll postpone for a period of 2 months or 3 months. Within that period, this clarity must be sought. And obviously, we know our courts would accommodate. This is a big issue. The Part B must be expedited. And in that 2 or 3 months, the whole thing will be cleared up, my lord. So that's all we're saying. We're saying avoid all this litigation.
So a 3-month suspension to work out whether Dr. Thorpe can still be on the JSC.
Absolutely.
Not a 3-month suspension for you to choose someone else through the parliamentary process.
Even that, my lord, if you like. Let's say for anything. But we have to be honest to your lordship and say that our advice is that the so-called substitution is not viable. But for the purposes of this case, my Lord, assume that it is. Assume that it's viable. So Your Lordship is quite correct. So we're saying three things. We're saying postpone for 2 or 3 months, pending one of three things. And again, even this is misconstrued. We say either and Your Lordship will find that in our notice of motion at 023. The final determination of the appeal against the orders of the judgment of the full court, Your Lordship knows what that means.
Yeah.
The second one, we say the final determination of Part B of the applications pending in the Western Cape. Let me pause there. Both of those things, my Lord, can conceivably be done within a month or two. I mean, if everyone commits to it, quite frankly. Because the pleadings are there might be a bit of supplementation here and there and so on, exchange of heads. We all know case management could make sure that those cases, I don't want to be overly optimistic, ahead, let's say by November or early December. But the third one is even lighter, my Lord. We say the final determination of the main application set out in Part BB. Now that case, my Lord, can happen next week, quite frankly, and it can be done, because that case is about one thing only. It's about the exercise that Your Lordship and I have just done now, which is looking at that letter. Remember, BB simply says the decision of the JSC to refuse postponement in sitting at schedule on the 7th is reviewed and set aside. That's it. So it's only about the letter. And then here are the more important words: whichever occurs first.
Yeah.
In other words, next week, in the next 2 weeks, if we set down that Part BB, and this whole thing will be over.
Yeah.
Or if we go to the Western Cape High Court, the JP there, the acting JP, and say, please expedite either the appeal or Part B. Again, the thing will be done, let's say, longer than 2 weeks in that case.
Just to get a sense of where this notice of motion goes.
Yes, madam.
If I were to decide that the JSC's decision was rational and can't be set aside,
yes,
what is left of your case?
Yes.
Can you tell me that?
Yes, I'll tell you, my lord. If you decide that the JSC's decision was rational in the declarator sense. Yeah. Yes. Well, that's why, my lord, we have the alternative prayer. So we say.
But of course, Part BB would have to fall away.
It may and it may not. I'll answer that, my lord.
Right. Okay.
Just now. Yes.
Yeah.
But because remember there's a whole issue about Rule 53 and what have you in BB. But I'll work with Your Lordship. If Your Lordship were to say, as Your Lordship might be entitled to, if Your Lordship were to say, look, the decision, I'm not giving you the declarator because I agree with the JSC's thing in the letter. And
I don't have to agree with it. I just have to decide it's rational.
Yes, that is rational. No, I mean it in that sense. It's like that right and wrong thing. Yeah. Then Your Lordship, the impact of that Your Lordship's order may or may not be to render academic assuming there are no appeals. Remember, it's a final order. Oh, by the way, let me clarify that, because this is said as if it's an insult, as if no. It is. Paragraph 2 is seeking a final declarator.
Yes.
There's not two ways about it.
That's how I understood it.
It's not they say, as JSC says, as we want them to believe that is interim. No, we don't want them to believe anything. So Your Lordship is quite right. It's conceivable that a granting or even a refusal of paragraph 2 might render the second part to be academic. But that's not important for the purposes of it's important for the second question that Your Lordship asked me, which is what happens then. Yeah. So that's the first thing that might happen. But what will certainly happen is that the prayer 3 will then have to kick in. And that's why prayer 3 starts with the words alternative to prayer 2. In other words, if you fail in prayer 2, then we say the interdict. And the interdict is asked for, and let me get into that, my lord.
So your prima facie right that you assert on when you ask for an interim interdict is more extensive than the right to a rational decision from the JSC. Is that what you're saying?
Yes, my lord.
So you rely on other rights?
Yes, and all these things about, the courts are going to fall apart and what they then come into it. And your lordship would do.
Well, that's because it's an interim interdict and the balance of
absolutely
convenience is relevant.
It comes exactly.
But the whether or not the courts are going to fall apart.
Yeah.
So what other than the right to a rational decision from the JSC, what rights?
Relief we seek. Okay.
What rights do you rely on for the purposes of the interim interdict? I suppose is the question.
Yes, my lord. Can I, if your lordship allows me just to do this first?
Yes, please.
I'm going to address that question of the alternative, but let me just wrap up the first part, my lord. If your lordship grants paragraph 2, then your lordship obviously then will jump paragraph 3.
Yeah.
And then what we want your lordship to go, we then go to paragraph 4, which is what I want to address there. So your lordship would then grant appropriate, just, and or equitable relief in terms of 172(1)(b), which we discussed, and that is the May, and or section 38 of the Constitution. And here's the important part, my lord, including the interdictory relief set out at prayer 3. In other words, your lordship may, in the wide discretion of just and equitable remedy, your lordship might say, don't sit on Monday. But the lordship could say something else. The lordship could say, as Mr. Ngalani said.
Well, I understand your submission to be, if I grant paragraph 2, that's a final order.
Yes.
I am then at large to exercise an equitable discretion.
Absolutely.
To make an appropriate order.
Yes.
May include interdictory relief or not.
Yeah, absolutely.
To give effect to the consequences of the declaration.
That's correct. Yeah. That's all, my lord. So that's the main relief. Dusted, done and dusted. Now let's come to your lordship's question.
Yeah.
If all of that doesn't materialize, then your lordship say, well, then what? Then we say, my lord, that there are 3 grounds, and I'm going to eliminate 2 quickly now. There are 3 grounds upon which your lordship could still grant the interdict. One is that your lordship would there's a case called Hoërskool van Warmelo.
Yes.
We've loaded it up and it's referred to in our heads.
Right.
In that case, my lord, and also this was reaffirmed in the impeachment case that we did I even think your lordship might have been there. But in the impeachment judgment, your lordship will remember that the...
So who were we impeaching?
The first respondent's president.
I don't think I was there.
Yes, maybe it was the UDM case, yes. But, my lord, in that case, the Constitutional Court affirmed this principle of Chapter J of Hoërskool van Warmelo. Actually, in another case, I was trying to say that matter was wrongly decided, but it is the law. Here's the law, my lord. Van Warmelo says that the conception that the passage quoted in our heads, your lordship will see it. Paraphrasing says this: it is not true that you can only do 172(1)(b) if you find in our favor in 172(1)(a). Yeah, it's in paragraph 19, page 19-12, 112, paragraph 122 of our heads, my lord. And it reads as follows. I won't read the whole thing. It says, the remedial power envisaged in section 172(1)(b) is not only, and the word is only, is not only available when a court makes an order of constitutional invalidity of a law under conduct under section 172(1)(a). So, Musanaka DCJ in that matter...
Well, it's when deciding a constitutional matter within my power.
Yes.
And that obviously goes much further than those 2.
Absolutely. Yeah. All of us, until that point, we thought the key to 1721B is that you must have the declarator,
yeah.
1721A. But Mr. Naka DCJ said no. The wide powers of the court are not confined to, you may not get your declarator, but the court can still. So that's the first basis upon which this court, my lord, could grant the, let's call it the relief in form, including the court could say, for example, I'm giving you this interim relief, but it's for 2 months. And in that 2 months, you must, what Mr. Ngalona was saying, in that 2 or 3 months, you must have done everything, and you must come back here if
yeah. No, I've got that.
Mm-hmm.
What I'd like to zero in on
yes.
is if I were not for any reason to be convinced that you're entitled to paragraph 2. Is there any other basis for an ordinary interim interdict? What other prima facie rights
yes.
do you rely on?
No, my lord.
Do you or don't you, I suppose, is the question.
Yeah. No, my lord. That's why I'm raising this case. I'm saying, even if your lordship is against me on paragraph 2, on prayer 2, your lordship on the authority of Van Warmelo is still able to grant 172.1b relief. And on that basis, that 172.1b relief may or may not include what you call, the interim order that looks like 2. It might be something else. That's where I was. I said, your lordship.
But I'd have to find some sort of
no, of course, I'm
constitutional breach or
yes.
Prima facie right.
Absolutely.
A violation,
yes.
prima facie violation of a right.
Yes.
Yeah.
No, my lord, we're together. I'm simply saying, I'm just registering the point that it is not totally dependent on 2. Okay,
yes.
Put that aside. Your lordship is then right. Now, if we now then confine ourselves into the let's call it the interdict, whether that interdict comes from 172.1b, whether it comes from section 38 appropriate relief, or whether it comes from the common law, for the purposes of this discussion, it doesn't matter. The only thing is that, my lord, if it comes from 172.1b, your lordship's discretion is much wider. If it comes from 38, it's even wider, because Forze, your lordship will know, Forze says that appropriate relief really means the court can even fashion new remedies that have never been seen under the sun.
As long as you don't reward punitive damages. That's
yes, unfortunately, for some of us.
Or constitutional damages, except in the most extraordinary of situations.
It is more than extraordinary, my lord. Forze was my first case in the Constitutional Court, 1996. But unfortunately, the court said no constitutional damages. Subject to that, yes, Forze says that. So your lordship's hand, in terms of 172.1b or 38, is really that wide.
Yeah.
Of course, when it comes to the common law remedy, then it's a little bit more restricted, because then you have to take into account outer and so on and so on. All the things that Mr. Ngalana was dealing with. Although, in my respectful submission, even on Mr. Ngalana's submissions, which he eloquently made on the common law relief, we should succeed. But a fortiori, if that is even remotely possible, then certainly on 172.1b and 38, we must succeed. But let me zero in on your lordship's question.
Yeah.
You see, in this realm, my lord, my work is much easier. Because once we are here now, I no longer, as I heard now, just now, have to say to your lordship, Dr. Hlophe's Section 19 rights were violated. What are Dr. Hlophe's Section 19 rights? His right to participate in the activities of a political party of his choice. That's obviously been limited by the non-postponement decision, and that can be debated. MK's right to have its member participating in the JSC, another Section 19(1) right, that's obviously also been prima facie at least infringed. Dr. Hlophe's dignity right to work and do and be a meaningful citizen that does self-worth will be implicated. Dr. Hlophe's Section 34 rights, my lord, to appeal, which goes to the whole debate we've had about Section 18. So I could do a catalogue of Dr. Hlophe's rights that will be implicated, including his right to have a rational decision from the JSC and all that. All that my burden is lighter in the following way, my lord. Now, all of a sudden, all I have to convince your lordship is that those are prima facie rights open to some doubt.
Yes.
Whereas in the previous section, I had to show your lordship that those were actual rights.
Yes.
So now it's even easier. It's plain sailing. Because your lordship could say, well, I'm not sure if the right to participate, but it's open to some doubt, but your lordship would still have to grant the interim relief. Couple that much lighter burden, my lord, with everything that Mr. Ngalwana has said about, for example, the impossibility of removing a judge who would be unconstitutionally appointed. All sorts of things, my lord, and I don't want to be alarmist. The kind of litigation that could come from the people who lose, not lose, who are not appointed next week.
Yes.
Because they can say, oh, well, this thing was improperly constituted, and also, your lordship gets the point. There can be a whole lot of things. And that's why we said in our letter, please, JSC, postpone for a short period to avoid a litany of possible litigation. The mind can go as far as it can as to what kind of chaos could happen. And that's what we call if the constitutional crisis that has been precipitated is allowed to continue.
Yeah.
So what's wrong with that, my lord? What is wrong with saying, please postpone for a month or two, put everyone on terms, and then come back and report to the court, so that all of these things, so that Dr. Hlophe's right to participate is protected, my lord. His Section 19 right.
And just address me for a moment on the proposition that those rights have been limited by the full court, not by the JSC.
No. Yes, thank you, my lord. No. That's a big mistake.
It's going to be important for your colleagues to hear what you have to say about that.
No, of course, because we know it's coming. That's a fallacy, my lord. What we hear about, as I said at the beginning, is not to assail that court. What we hear about is to assail the JSC's decision. The exclusion of Dr. Hlophe from the meeting next week is not as a result of that court order at this stage directly. It is as a result of the decision of the JSC unreasonably and irrationally not to accede to the postponement. That's a crucial point, my lord. And
but this is why I wonder whether the additional relief you seek doesn't ultimately collapse back into the proposition that the JSC was irrational.
No. Of course,
because the JSC's position is that it's bound by the full court's order. The full court's order placed Dr. Hlophe under restraint.
Yes.
If that order does engage the constitutional rights you rely on, then it's the order that has stopped Dr. Hlophe from going to the JSC, and the order binds the JSC.
Yes.
So either the JSC is right to draw that conclusion, rationally to draw that conclusion, or it isn't.
Yes.
If it isn't, then it's irrational, and paragraph 2 follows. But if it is, I wonder how you can impugn the JSC as having violated any of Dr. Hlophe's rights.
No, my lord. Please, lordship, just if you don't hear anything I'm going to say, just hear this.
Well, I've heard a lot, and I will listen. I'll listen to what you're about to say as well.
This, my lord. Remember only this.
Yeah.
Only this. Why we are in this court before you, my lord, this sunny Friday, is because the Judicial Service Commission refused to accede to a postponement decision. Now, and was saying, my lord, what excludes Dr. Hlophe, okay, put it this way, my lord, let's flip it. If the JSC had acceded to the postponement decision, Dr. Hlophe would not be excluded from the sitting next week.
Yes.
Okay, so now, and if the JSC had acceded to the postponement decision, let's say maybe even with conditions, what we're asking from your lordship, and say, okay, but we'll only give you 2 weeks or 2 weeks or 2 months or whatever it is, Dr. Klope would not be excluded from the sitting. So the proximate cause of Dr. Klope's exclusion from the sitting next week is the JSC's decision. That's it, my lord. It's not, of course, if you want to do the normal causation thing, you can say the sine qua non is the court order. But the real cause is the JSC decision. Yes.
Thank you, I have the point.
You got the point.
Yeah.
And my lord, let me then quickly go to paragraph 21. No, because we don't have time. I'll go to paragraph 35 of the Cape Bar case. I'll
35.
The Cape Bar case, yes.
Yeah, let me
SCA.
just get there.
Yes, yes. Acceptance of counsel's argument. This was now a criticism of the JSC counsel when they still thought composition means everyone must sit. But they've also changed their stance. It says, acceptance of counsel's argument for the JSC that matters relating to specific high court could be determined in the absence of the judge president of that court and the premier of the province concerned, or an alternate designated by both of them, which would be in direct conflict with the provisions of section 171K. What is more, I believe...
Just give me the paragraph number.
35, I'm sorry.
35, yeah.
Yes. Yeah.
I'm
now
with
in the
you,
middle.
thank you.
Yes. I've just read the first long sentence.
Yeah.
It says, what is more, I believe that it is clear from section 178 of the Constitution that the JSC has been created in a structured and careful manner. Its composition obviously sought to ensure that persons from diverse political, social, and cultural backgrounds representing varying interest groups would participate in its deliberation. And here's the killer, my lord. Any interpretation of section 178 which would allow decisions of the JSC to be validly taken without the unjustified exclusion, there's that expression, of one or more of these interest groups would therefore negate the very essence of the constitutional design. That is what we are here about. That careful constitutional design will be completely negated if there is an unjustified exclusion. And since we have already agreed about the approximate cause, the unjustified decision, unlike what my learned friends are going to tell you, is not the court order. Because they're going to say, oh, well, how can it be unjustified because there's a court order? No. The unjustified exclusion of Dr. Klope is the irrational refusal by the JSC of his participation. And therefore, on the authority binding upon you, my lord, of the SCA, your lordship has no option but to find that you cannot allow a situation where the careful design of, remember the careful design is even worse in this case, my lord. Normally they say 2 advocates, 2 attorneys, what have you. Here the constitutional drafters went further. They said 6 members of the NA, of which at least 3, minimum 3, must be opposition. So the Constitution is even more prescriptive. That means, my lord, all 6 could be opposition members, but at least 50% must be. Now we have a situation where it's 40%, even if Mr. Ngalwana's interpretation is wrong. We now have 40%, so that's constitutionally repugnant. Let alone Mr. Ngalwana's point, that you might even have the, what to call it, unjustified inclusion of the other 5, which makes it even more unconstitutional. So the SCA authority that is binding on your lordship, you'll remember in that case court, by the way, was also a bit not comfortable with this, but it said, but we're bound by Premier. So similarly, your lordship is bound by both Premier and Bar Council, and your lordship has no option but to find that the unjustified, irrational refusal of the postponement by the JSC is the is the problem that your Lordship must undo. And your Lordship must simply do, if to put it in colloquial language, your Lordship must simply do that which the JSC should have done, which is to say, okay, we'll postpone for a month or two or whatever it is, but this and that and that and that must happen, so that there's no threat of any constitutional crisis. Everyone is happy, nobody's excluded, nobody goes to court to do anything, and within that limited period, everything is done. And I can guarantee at least one of the three things, which is the Part BB, as I said, my Lord, can happen in a matter of weeks. The others, I'm prepared to concede, can happen in a month or two, because there'll be exchange of heads and what have you. But on the basis of the relief that is sought here, your Lordship has to, even if your Lordship is not with us on the declarator, and I cannot say how your Lordship cannot be with us on that, but even if your Lordship is not, your Lordship, we implore your Lordship with the greatest respect to simply then fashion, quote unquote, that remedy which will leave nobody, there'll be no chaos. Of course, there'll be inconvenience to all sorts of people, but as I don't want to repeat Mr. Ngalana's submissions, but the balance,
yes,
on balance, that inconvenience
yes,
would favor us. My Lord, those are our submission. If there's
yes,
anything else, I will deal with it in reply. But in sum, we say interpretation of the court order of Section 18 of Section 178, and we say if you interpret those three instruments correctly, then it is in our favor. And then we say, give us the declarator for the reasons that have been granted, and then paragraph 4. But we say if we are wrong for some reason, then we have the lighter burden in terms of the alternative prayer. As the court pleases, my Lord.
yes, thank you,
Mr. To your Lordship.
Thank you, and thank you for just about keeping to time.
Thank you, my Lord.
I'm going to take a 15-minute tea adjournment, come back at noon, and I'll hear from Mr. Mainiche.
As court pleases.
Yes, thank you. Court adjourned.
Thank you.
Right. and there is a constitutional test for interim relief by way of an interdictory relief, which this court can grant without regard to the requirements for interim relief. With respect, there are two tests. What Alta made clear in the Constitutional Court at paragraph 45 is that even under the constitutional dispensation, there is no need to develop a new test. The test remains that, but seen in the light of the impact of the Constitution, and that's why you look at separation of powers and so on. So just to clear that even when looking at whether the consequential relief that our learned friends contend for, Mr. Mpofu, under following upon a declarator, if that is to take the form of an interdictory relief or a postponement, that's an interdict because he's suspending the proceedings, he must still satisfy the requirements and heightened by the requirements of Alta, because this is to restrain the exercise of statutory and constitutional powers and to restrain the fulfillment of those functions by the JSC.
Well, the separation of powers harm, if it becomes relevant, is the same as what you say tips the balance of convenience in the JSC's favour, isn't it? I mean, all of the reasons why in outer the Constitutional Court says that there's separation of powers harm are the reasons given in those two affidavits by Ms. Pillay and Mr. Toby as to why the JSC should be allowed to get on with it.
Yes.
The separation of powers harm is about allowing the state to get on with its statutorily mandated functions.
Exactly.
And those affidavits, well, this is what's going to happen if we can't.
Yes, quite.
Those inquiries sort of fall into one another, don't they?
Yes.
If you get to an interim interdict test.
Yes.
Yeah.
All I was saying, my lord, is not as if the consequential relief that he asks, that MK asks under Section 172B, if it takes the form of an interim relief, is somehow assessed outside of the Sutlo-Hello test. No, it is in that test.
Thank you.
To turn to the reasons, my lord, I'm going to refer, my lord, to our heads, and I'll follow a lot of the structure of the heads. At page, paragraph 39.1, we reproduce the reasons. The first reason is that the JSC was bound by the judgment and order of the Western Cape High Court. And that is addressed in full in the heads from paragraph 84. Now, there are important constitutional provisions which require the JSC to not only obey the orders of the High Court, but to assist to ensure that those orders are taken into effect. And that is Section 1C of the Constitution, our rule of law provision, the supremacy of the Constitution, and all of both of them bolstered by Section 165.5 of the Constitution, which says orders of courts are binding. They are binding until they are set aside or suspended by appropriate orders of those courts. And initially, the suggestion in the founding affidavit for the MK party was that the JSC is irrational because it could not be bound by a judgment of which it wasn't a party. And you will see that my learned friend hasn't persisted, and that was clearly wrong, because the judgment of the Western Cape High Court makes clear that the JSC was a respondent, and it abided the decision of the court, and that means it's bound by that decision. The second point they make is that somehow the application for leave to appeal suspended that order. You will see in the letter to the JSC, and this is very important. In the letter to the JSC, and perhaps I can just point the court to that letter.
Yes, it's an annexure to the
they went certain themselves on the implications of the application for leave to appeal. I flagged it. But
letters at 02-120.
Yes, but the only point I make is that they said it's unclear, it may be suspended, perhaps it's not suspended. They were not categoric that the application for leave to appeal has suspended the order. Because if that was the case, their demand would have been a different one to the JSC. it wouldn't have been postpone the postpone the proceedings. It would have been confirm that my client will be allowed to attend, because the operation of the High Court order has automatically been suspended by the application for leave to appeal. That's not what they asked, which shows precisely that in fact, the letter is very specific that judgment remains operative. Yes. In fact, they make it clear in that letter that the order and judgment of the High Court remains operative. And then they hedge their bets by saying there might be some debate, maybe grey lines. I'll show you that by reference to an argument my learned friend Mr. Mpofu made to this court. He persuaded the court that an interim interdict is an interlocutory order, and it doesn't automatically, a leave to appeal doesn't automatically suspend other than by a court order. You will see.
Well, your point is, if the application for leave to appeal did suspend, then there'd be no point in postponing either.
They wouldn't be asking for
Dr. could just come.
Yes.
Yeah.
And then they would be coming to you to say the JSC refuses us to go, refuses Mr. Thorpe to attend, when in fact the order of that court has been suspended. Yes. You will see that it's paragraphs 10 and 11 of that letter, and Malot can have a look at it. Paragraph 10 says, this
I have it.
that is really what we are referring to. It says, for present purposes, we therefore accept, as we are legally bound to do, that the judgment, however erroneous, is legally effective until the appropriate proceedings may have been instituted and finalized in terms of Section 17 and or 18 of the Superior Courts Act. That is common cause, they say. What is at issue for now is not the legal effectiveness or executability of the judgment, but its legal impact on the 7 October sitting. So, and then they have it may well be that there is some debate at paragraph 11. But they told the JSC, it's common cause that judgment and order remains effective. How they today complain that the JSC says it is bound by that order because that order remains effective, it's really a lawyer's argument. At the point when the client wrote on instructions and advice, it said it was common cause. But that's probably by the by. The real point is it a wrong conclusion or irrational conclusion for the JSC to hold that that judgment remains effective and is binding on the JSC? We submit not. And we deal with that from paragraph 88 of our heads. You will see that we first highlight the two sections that are the three sections of Section 18 subsections, 18.1 and 18.2 and 18.3. And we refer to the judgment in Old Mutual and others with Moyo, in which my learned friend and I, Mr. Mpofu, were on opposite sides initially, and then I fell off subsequently. But what we had done, because my learned friend succeeded in obtaining an interim interdict, restraining for the interim pending an outcome of a Part B relief, the dismissal of a CEO of a company, Old Mutual. Old Mutual filed a notice of application for leave to appeal, and there had been ongoing disputes about whether he's allowed to return to the office in light of the order of the court or not. And Old Mutual sought to argue that the order had final effect, and therefore the leave to appeal automatically suspended the order. On the eloquence of my learned friend, the court found, and we quote from paragraphs 88, the interpretation that the applicants want to assign, and that's Old Mutual, to the reinstatement order is manifestly farcical. I'm at a complete loss why anyone would want to read a sentence that states that the first respondent is temporarily reinstated pending the finalization of Part B to be final. A plain reading of that sentence is clear. Even with the interdict relating to the prohibition of the appointment of another chief executive officer, it is apparent when reading it against the background of all the papers in the application that the intention is for it to apply until the finalization of Part B. An interpretation that is in stark contrast with the quoted passage from Ndumeni Municipality case Supra stands to be rejected as bereft of reason, and the orders that this court granted on 30 July 2019 cannot accommodate a construction that they are final and definitive. On a proper reading of the order of this court dated 30 July 2019, and having regard to what was held in Ndumeni Municipality case Supra on how documents should be construed, the relief sought and granted was interim in nature. Despite it being interlocutory, it was in the interest of justice that the order should nonetheless be appealable. That was a separate question on appealability and the interest of justice. But the point is, it's interlocutory, and it doesn't automatically suspend the order of the court. And with respect to that, the court took
interlocutory and not having final effect.
And not having final effect. And interim orders don't have final effect because the judgments that they render can be reconsidered and changed by the court hearing a final application for final relief. So the review court...
You've got to apply the Zwini test.
Yeah, the Zwini test. And that's
it comes in and out of fashion, doesn't it? But
for
the purposes of this... For the purposes of this case, I think the finality of the, or non-finality, if I could put it like that, of the full court's order is to be determined by reference to that test.
Yes, quite.
So what your submission is that the first leg of that test is satisfied because the full court's order is open to interference at a later stage by the same court.
By the same court. It's interlocutory also in the sense that it's incidental to the main relief. It's relief pendente lite. The pending proceedings are the Part B proceedings. And that's why it's always linked to those proceedings. If you can't have an interim interdict in the A, it must be linked to pending proceedings. In that sense, it's interlocutory, and we refer to the judgment at paragraph 91 of South Cape Corporation. It doesn't have the effect of res judicata in the wide sense, because it doesn't finally determine the rights of Dr. Thorpe, for instance. It's not finally determinative of his rights. Those rights, on all accounts, will be determined under Part B or on appeal. So it is that order is clearly and unambiguously interlocutory. And the effect of the application for leave to appeal is not to suspend that order, and the JSC was correct in taking that decision. But I don't have to persuade my lord that the JSC was correct. No. All I have to show is that it was rational in taking the decision. Now, I don't know which judgments it read, but I assume it might have read. One of them might be Marlene Friend's success in Old Mutual. And that would be sufficient to render that reason rational. The second reason, my lord, in the reasons is that the judgment and order of the Western Cape High Court did not set aside Dr. Thorpe's designation as a member of the JSC. That much is common cause. That he remains a member. My learned friend, Mr. Galwana, emphasized that point. So he remains a member of the JSC. The only thing that has been interdicted in the interim is for him to attend JSC meetings. But just for the court's reference, we deal with that from paragraph 94 of our heads when the court looks at that point. But I'm not going to dwell on it.
Yeah.
The third reason, my lord, is that the October sitting and any decisions that flow from it will not be rendered unlawful, even if Dr. Thorpe is not able to attend. And first we make the point that that is a finding which the High Court in the Western Cape itself made. And it made those findings at paragraphs 56 and paragraph 68 of the judgment. And in fact, related to the different point which our learned friends make, and I'll come back to it, which is to suggest that the judgment of the High Court impugns the designation of the other five. That, with respect, is just wrong. And it's wrong for the clear reason that my learned friend, Mr. Mpofu, read out from a paragraph, but he didn't complete the reading, and that is paragraph 56 of the judgment. And my lord, always one understands the effect
56 of the 2013 case.
I beg my lordship's pardon? Or is 02-66, what's your?
Oh, have you got it on?
Okay, that's
Judicial Services
yeah,
Commission
mine is
versus
on
Cape Bar Council.
02-66, yes.
Judicial Services Commission versus Cape Bar Council. Is that the decision?
No, I was looking at the High Court judgment in this case.
Oh.
It is, it's in the, it's
sorry.
attached to the founding
yes,
papers.
Yes, no, sorry, I was looking at the wrong judgment.
Yes.
Carry on. Paragraph
So,
54.
56.
56.
So, my learned friend read part of it to demonstrate that the court was mistaken by referring to quorum instead of composition. But if you had read further, what we want to do is to read further than that. So it says the respondent's submission that the JSC would not have a quorum in order to take valid decisions if Dr. Klope is interdicted from participating in that forum is incorrect. In acting the Premier's case, the court pointed out that the majority support for decisions required by Section 178(6) is the majority of members entitled to be present, according to Section 178. In that case, the issue was whether the Premier's attendance was necessary. The court concluded that it was bearing in mind 1781K of the Constitution. In this case, the absence of Dr. Klope and on the JSC would not be significant.
Yes,
Mr.
Mpofu was quite emphatic on this point.
Yes, but he didn't read the last sentence, my lord.
Yeah.
There would still be 5 NA members represented on the JSC, constituting a majority of such members. I'm making a different point, that if the court impugned the designation of the 5 members, it wouldn't be making the statement at paragraph 56.
Oh, I see.
Yes. Yeah. It didn't impugn that because, my lord, the court's reasoning must be read to its logical conclusion. When the court says in the context of Dr. Klope, the National Assembly failed to exercise, to appreciate that it had a discretion and to exercise it. It's because in his case, if the discretion was exercised, they would have taken into account that he had been removed as a judge. And you will find that in the reasons. But you wouldn't reach that conclusion with the other 5 members. So it's not simply to read half bits of the judgment and say, but they're saying they're impugning the entire, the way in which the JSC exercised its discretion and did not stop at only Dr. Klope.
I mean, to be fair, Mr. Mpofu didn't really concentrate a great deal in his argument on that point.
Yes.
What he was saying was that for the same reasons as was found by the Supreme Court of Appeal in the Cape Bar Council and Premier of the Western Cape case,
yes,
non-attendance by Dr. Klope in this instance means that the JSC is improperly constituted.
Yes, I'm coming to that.
Yeah.
Yes.
That just seems to be the main point.
That was the main point.
I understand what you're getting at,
yes,
but insofar as the rationality of the decision of your client is concerned, it seems to me that that's the first of 2 critical points you have to meet.
Yes. I mentioned that point because the reason they say the JSC's decision is irrational is first for the reason I've already addressed about the binding effect of the judgment, but they also say the composition would be unconstitutional. I'm coming to that now. But Mr. Ngalwana, representing Dr. Klope, added the point that in fact there are far more. There is an issue the JSC ignored, which is that the High Court judgment impugns the designation, including of the 5 other members. And I took advantage of, because I was at that paragraph, just to highlight that point, that in fact in that submission is inconsistent with the content of the judgment itself and how it hangs together in reasoning why there were sufficient prospects of success in the review of Dr. Thorpe's designation. It's because the failure to exercise a discretion ignored a relevant factor, which is that he was removed by the same body, which
Yes.
it doesn't apply to the others.
Yes, but I think Mr. Ngolwana clarified that his submissions in that respect really went to the balance of convenience. Not sure he was suggesting that the JSC was irrational because it had taken the wrong view of the full court's decision on that point.
I'm indebted to my Lord to clarify that, because then in respect of balance of
Because
convenience,
I essentially put him, I didn't put it in these words, but first of all, you've got to look at the order.
yes,
The order doesn't say anything about the other five. And secondly, if there are passages of this judgment that might be read in that way, they are passages that lead to an interlocutory order.
yes,
Not final definitive findings of the fitness or the lawfulness of the appointment of the other five. And that's when I think Mr. Ngolwana said, well,
it goes to balance.
it goes to balance of convenience, really.
Yes.
It's not about rationality.
I appreciate
Yeah.
that, my Lord, that
Yeah.
clarification. The submission I would make is, when we get to balance of convenience, that doesn't get into the port.
Yes,
It
yes.
doesn't
Well, I
get
mean,
anywhere.
you may well have your submissions to make there.
Yes. Just going into the Constitution then, we start that, my Lord, at paragraph 52 of our heads.
Yeah.
And we start off by setting out section 178 and making a couple of submissions related to that. Paragraph 54 is simply to say that subsection 3 provides that members of the Commission, other than those designated by the NCOP, serve until they are replaced by those who designated or nominated them. Then we refer to decisions and how decisions are made. And 178, it's where certain designated members may not be able to attend, and there's provision for alternates. And under 57, we make the point that the clear import of section 178(1) of the Constitution is that once persons meeting the criteria of subsections A to K have been designated in the manner and by the person or entity prescribed, the JSC becomes properly constituted. So the Constitution and presence at a meeting are two different concepts.
Yeah.
We make the point. And then we refer to the 50-50 split, which is 178(1)H. And 59 is the effect of the Western Cape High Court order, which is simply only that he's prohibited from participating. He remains a member. And so the High Court order has not affected or altered the split, which is a composition issue, the 50-50 split. It's an issue of attendance, whether you will maintain the 50-50 split, and I come to the attendance issue.
Yeah.
And while the courts in 62, while the courts have acknowledged that the list of office bearers composing of the JSC is carefully structured, the cases confirm that the absence of a JSC member does not, without more, invalidate the proceedings or the JSC or its decisions. And that's where we tend to the relevant judgments, because they make it very clear that it is only when the absence lacks proper justification that there might be a nullification of JSC proceedings and decisions. But where there's proper justification, there isn't. And that's a ratio, that's the reason of principle, that all of the judgments that our learned friends referred to are discussed in the Thorpe case, which is a case involving the first applicant and the second applicant.
The full court decision in this division.
The full court decision in this decision, which is binding on this court. We summarize at 63 that Dr. Thorpe had relied on the Skirrod principle that if a statute prescribes specific office bearers to attend meetings and does not prescribe a quorum, it's assumed that all of them must attend, and that otherwise the proceedings where not all attend would be a nullity, and the decisions made would be a nullity. My Lord, the judgment of the full court dealt at length with the implications of all of the SCA judgments that our learned friends have said to my Lord, they bind the court. And my Lord will see at paragraph 30, from paragraph 38 of that judgment, of the full court judgment. It follows on a discussion of the skill-hold principle and says at 38, the SCA, however, in JSC versus Cape Bar, considered itself bound by its judgment in Premier SCA, saying that it follows that if the JSC cannot take a valid decision in the absence of either the Premier or her alternate, the position can be no different with regard to the absence of both the President of this court and his deputy. However, like in Premier, the SCA held that it was because of the lack of justification for the absence of the President of the SCA and his deputy that the JSC was not properly constituted at its meeting, and that its decisions at that meeting were therefore invalid. What emerges then from this case is the inference that proceedings will not be regarded as a nullity if there are justifiable reasons for an absence or exclusion of a member entitled to sit. The justification qualification was crucial to the findings in respect of composition. Therefore, it would be a mischaracterization of those cases to say that they are analogous to the present matter or that they provide authority for the proposition advanced on behalf of Klope JP in the present case. It would be a mischaracterization of those cases to say that they dictate that generally, in the absence of the President and Deputy President of the SCA, the proceedings of and decisions taken by the JSC were invalid. Those cases tend on the absence of a justification for non-compliance with the composition requirements. They are therefore, as was submitted on behalf of the JSC, wholly distinguishable from the case with which we are seized. And why? Because in this case we are furnished with reasonable and adequate justifications for the absences of Maya and Petsy DP. The justifications of Maya P and Petsy DP were uncontested. Both judges explained their absence on account of their personal relationships with Klope JP, so it's a conflict issue. On the basis of the above cases, then, their justified absence do not render the proceedings a nullity. There were valid reasons for their non-attendance. They were not unjustifiably excluded, nor were they unjustifiably absent. In the light of this, there was a reasonable justification of their replacement. My Lord can read further. And here, there is justification. The justification for his exclusion is the binding court order of the Western Cape. Our learned friends can quarrel with that judgment. What they have failed to do is to get its operation suspended so that it doesn't provide justification for his absence from JSC proceedings. The argument of our learned friend, Mr. Ngalwana, starting off under interim interdict with what is the right. He says he's got a right to participate in JSC proceedings. My learned friend, Mr. Bofu, says that's a political right. He's got to represent, take part in the activities of MKP. Yes, true. But why can he not exercise those rights now? Because there is an interdict, which in terms of Section 1 of the Constitution, read with Section 2 and 165(5) of the Constitution, is binding on the JSC and on Dr. Klope. He can't go there and attend without being in a contempt of court. And that is the reason why he's not there. Our learned friend says somehow it is the JSC that is depriving him of the opportunity to participate, because if it postponed, well, they can't say if it postponed the proceedings, he would participate. All they can say is if he postpones the proceedings, there might be clarification whether he should or shouldn't participate, because one can't proceed on the assumption that he's going to succeed in his appeal against the interim court order of the Western Cape High Court, or indeed in Part B, they might find against him. So he might never return to the JSC, ultimately. So one can't approach the argument on the basis that if the JSC postpones, Dr. Klope is going to participate. No. If the JSC postpones, Dr. Klope will vindicate the case he has against the parties that went to court, whether he should be in the proceedings or not. And the only debate, the real debate, is should the court restrain the fulfillment of an important constitutional function to wait for Dr. Klope to vindicate his rights, which he has so many avenues to vindicate. He could have suspended the operation of the judgment. He can expedite the proceedings. And because the JSC proceedings are not invalid by reason of his absence, no constitutional provision is breached if the JSC in the meantime carries on and expedites proceedings to clarify his position. There is no reason to jeopardize the functioning of the courts, of the judiciary, and the proper administration of justice, just so that in the unlikely event that the court had him in Part B and in his appeal, he might succeed. He might succeed, my lord. He may not succeed. So with respect, all three reasons that the JSC offered are not only rational, they are correct, my lord. And there is no basis for this court to find that the JSC acted unconstitutionally as the declaratory relief seeks to the court to do. And I've addressed the fourth basis, which was dumped into the balance of convenience category, but that too doesn't assist. So when our learned friends say, but the court must look at the constitutional impacts of not having Dr. Thorpe on the JSC, that is an argument that they've made and they failed on before the Western Cape High Court, because the Western Cape High Court would have been met with an argument that Dr. Thorpe has political rights, he must carry out a constitutional duty on the JSC, you cannot interdict it. When you do that, you're upsetting the whole constitutional arrangement, including the 50-50 split. The High Court said the 5 will be there. That's sufficient. The majority will be there. That's sufficient. That finding and that judgment is binding on the JSC, is binding on the applicants, is binding on this court, because it hasn't been suspended. And it will only be set aside on appeal. And the courts have made it very clear that the fact that a judgment may be set aside on appeal doesn't mean in the meantime, unless suspended by a court under Section 18.3, is not binding, continues to bind. The ratio continues to bind. So with respect, we submit that there is no case for the declarator. The real point why you have a declarator put up like that is that MKP is quite aware that it would face a difficult hurdle to clear the outer test for interim relief. That's why it wants the court, in a sense, to read into Section 172B of the Constitution and Section 38 to allow for a court to grant an interim interdict in the A without meeting the 4 requirements for interim interdict, which have been clarified by the Constitutional Court as being constitutionally compliant, and there's no need to fashion a new test. And when I come to interim relief, which is what I will tend to, it is that test which must be complied with, and we submit that is not met at all. My Lord, if I can tell...
Just on that point, if an organ of state takes a palpably irrational decision, must the court still consider some variant of the outer test or the outer test before it says so and grants appropriate relief? I mean, it just seems to me that the submission that you just made is either not correct or has its limits.
Yes.
It's one thing to say, well, if a party before court has a good chance of succeeding in an application for final relief, and the respondent is the state, and the state has special duties, one has to take account of the impact of restraining the state from fulfilling those duties pendente lite. And that is separation of powers harm. And it's usually located at the balance of convenience leg of the stage, of the test.
Yes.
But it is, I think, conceptually distinct, isn't it, to say, well, actually, what we want you to decide is not anything on an interim basis. What we want you to declare is that here and now, this decision was irrational, and because it's irrational, can have no force or effect. Those are two distinct arguments, aren't they?
Yes. So we would submit that if the court finds that the JSC decision is rational, there's no scope for interim interdict being granted.
Yeah.
Because you would never have you can't demonstrate a right that's been breached there's no right to a postponement. There's only a right to a rational decision, a proper consideration of your request for a postponement and a rational decision. So once the...
Well, if I were to decide that the JSC's decision was irrational. Irrational.
Yes.
Irrational. Should emphasize our syllables, shouldn't we? Then it follows from that I must conclude that the decision was taken in breach of Section 1C of the Constitution.
Yes.
Follows from that I have a just and equitable power to determine an appropriate remedy under Section 172.
Accept that.
Yeah. That's a completely different railroad from Umkhonto we Sizwe or Dr. Hlophe's rights have been breached prima facie by the JSC's decision. They may or may not in due course get a declaration or have a court conclude that finally and definitively that those rights have been breached.
Yes.
And for that reason I apply the interim interdict test, which includes outer, because the JSC is an organ of state.
Yes.
Those are two manifestly different propositions, aren't they?
Yes, they are. The only point is when the court considers just an equitable remedy and following upon a declaration that the JSC decision was irrational, the factors that we raise under balance of convenience are still relevant in that they speak to the public interest.
Yes.
Because that just an equitable remedy, under just an equitable remedy, the case law is quite clear that public interest is paramount. So you would still consider whether it is a case in which just because a declaration of invalidity has been issued, there must be a consequence that the proceedings mustn't take place. They are either postponed or interdicted. So it's not an outer structure, but the facts that are referred to in the assessment of interim relief, especially in relation to balance of convenience, and harm.
It's conceivable that a court could say, well, I don't think the JSC was rational in this particular instance.
Yes.
But here is a rational basis on which they should proceed.
Right.
Well, there's no reasonable basis on which they shouldn't proceed.
Yeah.
Therefore, it's just and equitable that they proceed.
Yeah.
That's conceivable. I'm not saying that's what the facts of this case say.
Yeah.
Not even saying that I would even get that far. But I could just leave it at a declaration, couldn't I?
Yes.
Depending
So
on the facts.
Quite. It's conceivable that the court might say, of the three reasons the JSC gave, one or two are not rational, and in its view, they are the predominant reasons.
Yeah.
And therefore, they render, I think that's the approach that the SCA adopted in Westinghouse, where they said there was a dominant reason, is in a tender context. The reason you have applied is a reason that was not stipulated in the tender evaluation criteria. Therefore, that's an impermissible reason and is the predominant reason, and it renders the decision irrational.
Yeah.
So if, on the other hand, assuming the court were to find that the JSC was correct, that the judgment is binding, the JSC was correct that the proceeding with the meeting on Monday is not unlawful because of what the full bench says. But there's some other reason for which it would have been in the interest of justice, or a factor that the JSC didn't consider should have been considered, and the court takes the view that renders the decision irrational and can warrant a declaration of irrationality, of invalidity. It doesn't follow that there must be a postponement and or an interdict. Yes, but I'm very indebted to the court for drawing, for splitting the routes, as it were, to the outcome. But one can wish away what has been pleaded. Yes.
Thank you.
I've got 5 minutes left.
Yeah. By my count, 2. But
my learned friend said I can borrow another 5.
It's absolutely fine.
Another 5 from them.
you're in a position to round off your submissions,
Yes.
are you? Then that's fine. Thank you.
On the requirements for interim relief, my lord will find our heads from paragraph 97. We've set out 4 reasons why he doesn't have a right, Dr. Klope. First, he doesn't have a right to attend the proceedings because of the interdict, which is in place. Secondly, there's no right to a postponement. He was entitled to a rational consideration. That's what he received. And the court has already found that there are sufficient prospects of success in the review of his designation that would annul his right to participate, so to speak, because that's what the court found.
Yeah.
And the fourth is the appeal right doesn't require an interdict, my lord. There's a special remedy in section 18.3 and 18.2 if you want to protect that. And on balance of convenience, we've said much of what we need to say. It's all in the affidavits. It's really his interests versus the public interest here. And also, where the right is not strongly established, balance of convenience would have a much more pronounced consequence. And on irreparable harm, we've highlighted the case in City of Tshwane, which says that one of the crucial elements that must be established before an interim interdict can be granted. And that irreparable harm is the irreparable harm linked to the relief that you seek, and is your irreparable harm. In this case, he's talking about irreparable harm to the Constitution, to the JSC, to the public interest, but it must be harm that one can link to him and is irreparable. And we've submitted that is reparable, because if he succeeds in his appeal or in Part B, he comes back. In the meantime, the proceedings go on because they can do so lawfully under the full court judgment of this division. Alternative remedy, we've mentioned all the alternative remedies that he has. The section 18.3 remedy for him to attend, because there's no point in postponing. The whole point here is about him attending and participating. Is the Part B and the appeal, which can be expedited. And at the end of our heads, from paragraph 109, we have a section dealing with dire consequences for postponing the JSC's October sitting, and that is all about the administration of justice, my lord. That is a factor that applies to the balance of convenience.
Yes.
My lord, we submit that on all of what we've submitted in the affidavit, in the heads, bearing in mind this is urgent court, this application should be dismissed. We don't seek a cost order. We simply ask the application be dismissed.
Thank you.
As the court pleases.
Mr. Bishop.
My lord, I'm not going to deal with the issues in the same way as my learned friend looking at the prayers. I intend to address them in the following order. First, I want to make a few remarks about the nature of the challenge that's before this court. Then I'm going to deal with the designation of the 5 other MPs, other than Dr. Klope. Then I'm going to deal with the presence of Dr. Klope at the JSC. And those are the 2 main grounds on which this relief is founded. Then I'm going to deal with section 18 and 18.2, whether this is final interim, whether it matters or not. I'll then deal very briefly with the interim interdict requirements. I would have covered most of the ground by then, but I have a few remarks. And then finally I have a few things to say about remedy and the relationship between section 172, 1A and B. The first point is that prayer 2 of this application is a review. It's framed as a declarative, but what it really is a review of the postponement decision. Because if this court were minded to grant that declarative, that would trigger not only its power, but its obligation under section 172, 1B to consider what other just and equitable relief to grant, which may include a reviewing and setting aside, or may include some other relief. But that's exactly what happens in a review, is the court decides whether the decision is lawful or unlawful, and then decides whether to set it aside or not, whether to suspend it, whether to grant other relief. It's a review, final in effect. That much has been said repeatedly. But what is it a review of? It's not a review of a final substantive decision by the JSC to appoint or not appoint certain judges. It's a review of a step in the process, a decision to have a meeting. So it's a review of a decision in medias res. And there's direct precedent for this issue, which is the case of the Public Protector of South Africa versus Chairperson Section 1941 Committee. The citation is 2023 ZAW CHC 73. And that was a case in which the former Public Protector, Advocate Mkhwebane...
Give me that reference again. Is it in your head? 2023
ZAW CHC 73. That's the Sapley reference.
Okay. 2023 ZAWCHC
73.
73.
So it was a decision of a full bench of the Western Cape High Court. And what happened is Advocate Mkhwebane, during her Section 194 impeachment proceedings, brought an application challenging various decisions that had been made, to refuse postponements, to not recuse themselves, various decisions that the chairperson and another member of the committee had made. And including a decision not to grant a postponement at a certain point. And what the court said is that when you're challenging, this was in the context of Parliament, we submit the same applies to the JSC, is that ordinarily courts will not entertain reviews of decisions in medias res. What you're required to do is wait for the final outcome, and then you can review that decision. And there's good reasons, because otherwise organs of state, like Parliament, like the JSC, are hamstrung, are unable to do their duty. So it's only where there's grave injustice or irremediable harm that cannot be remediated by review in due course that a court will even entertain reviews in medias res. But the other reason I mentioned this is it's important to think what the JSC had to decide here is, should it proceed with a hearing where it is going to interview candidates and make decisions or recommendations to the president about who should or should not be appointed. And what I had to decide is, well, is there a risk that if we go ahead with this hearing, that our decisions that we make will be compromised in some way and may be liable to be set aside? And I had to take whatever risk it thought might exist and weigh that against the cost of granting the postponement. And the cost has been set out in detail, and it's obvious. There's a cost to the administration of justice because judges will not be appointed, and there's fruitless and wasteful expenditure of 3 million rand at least. So those are the obvious costs, and that's what the JSC was doing. And so it's weighing that risk. And the question for this court is the way it weighed the risk irrational? Was it irrational for it to say, well, I don't think there's much risk that these decisions, any decisions we might take, might be set aside. The cost of postponement is massive, so I'm going to refuse the postponement. Was that rational? It was obviously rational. And I'll get to why the risk is, if there's any risk, is incredibly low in this case. And so what the JSC, the decision it took was, as Mr. Mayanecha said, not only rational but correct. So that brings me to the first sort of substantive basis, which is the position of these 5 other members of Parliament, the remaining delegation of designees. And before I get there, I think it's important just to clear up some lingo. The difference between composition, attendance, and quorum. And I think this is usefully set out in the JSC's heads. So we disagree slightly with what they say. But the composition is, have these people been designated, the people listed in 178.1. And there's no dispute that they've been designated. Everybody, including Dr. Klopper. The next question is, who needs to attend of those people have been designated in order for the JSC to act lawfully? So I'll get to the case law later, but we submit that what the position is all the designated people must be invited, they must know about the meeting, and they must either be present or there must be a justified reason for their absence. And if those conditions are met, the JSC can go ahead and take lawful decisions. The word quorum is somewhat misleading in the case of the JSC, because nowhere does it set what we traditionally call a quorum, where it says X percentage of members must be present. What it says is a decision must be taken by a majority of members. So any decision must be a majority of the members, not members present, members of everybody of which the JSC is composed. So if 2, 3 members are absent because they're sick or a court interdicted them from attending or for whatever reason, they still need a majority of the members in order to take a decision, not a majority of members present. But that's not a quorum issue. That's a how many votes do you need to take a decision issue. And sometimes these issues get confused, that they use it somewhat interchangeably. But if one looks at the full court judgment, it's very clear that what they're really concerned about is attendance. It's not composition. It's not quorum, which isn't really an issue at all, it's attendance. So, turning to the question of these 5 designees, we say there's 6 reasons why the JSC was correct to conclude, 1, there's no risk, but even if there is a risk, it's a minuscule risk. The first reason is that only Dr. Klopper was before the High Court. The DA, Full Corruption Watch, only challenged Dr. Klopper's decision. And Mr. Mayanesha took you to the paragraph where the Full Court expressly says it's not affecting the position of the other 5. It says they will attend. So that was clearly the position. The second reason is that their designations are valid until set aside. Odekrol, Kurland, basic public law principle. And in this case, not only have they not been set aside, they haven't even been challenged. It's a very peculiar feature of this case that the Part BB review is framed as a review of the postponement decision, not a review of the designation of the 5 members, which is then put up as the reason why the postponement was bad. Nobody has challenged it. eNCA, Dr. Klopper haven't even said that they intend to challenge it. And there's probably a good reason for that, because their position in front of the full court was that the mistake of law rubber stamping review ground was bad. And so if they were to challenge it, they'd be advancing an argument directly contradictory to the one they used to defend Dr. Klopper's designation in the challenges brought by the 3 applicants. The third reason is that whatever the full court might have said is not final. It's prima facie. It's very clear that its findings are prima facie findings. And we know that particularly because it refused expressly to grant final relief that was sought before it. Freedom under law didn't seek interim relief. It asked for final relief on these same grounds. The DA called it mistake of law, Full called it rubber stamping, but the same ground. And Mr. Trengove, who was then arguing for freedom under law, argued vociferously to the, well, maybe that's wrong, argued persuasively.
Trenchantly.
Trenchantly, that's
We
the
want
correct
trenchantly,
word.
do we? Yeah. Okay.
Trenchantly.
Trenchantly.
I wouldn't say cogently.
That is the kind of word I would associate with Mr. Trengo.
Trenchantly, that the court had no choice but to either grant or dismiss that relief.
Yeah.
And the full court took a different view. It took the view that it wasn't obliged to decide it and did not decide it.
Mm.
So we know it was only prima facie. Yes, some of the language is strong. We see that in interim interdict cases all the time.
Yeah.
Judges maybe express themselves trenchantly. But as a matter of law, what was decided is there is a prima facie right and nothing more. The fourth reason is that there is a substantive difference between Dr. Klopper on the one hand and the 5 other designees on the other. And the important issue is when these nominations were made, the 6 nominations, there was no objection by any political party to those 5. The only objection was the objection raised by my client, the DA, and it was only raised with respect to Dr. Klopper. And if you look at the debate, the Hansard, the debate was only about Dr. Klopper. So in substance, there was agreement. Not only was there which was the position for Dr. Klopper, well, we may not like him, but there's nothing we can do about it. For the other 5 groups, no, we like them, we think they're great. Let's send them to the JSC. So whether the same ground of review that may or may not in due course succeed against Dr. Klopper will succeed against the 5 others seems very doubtful. They're very different cases. And because no one's reviewed them, we don't have the record, we don't know much about them. But, I mean, there's a further point that even if a court found that there was some technical irregularity in the designation of those 5 people, what remedy is it going to grant in those circumstances? Is it going to set them aside with retrospective effect? Or is it going to say, look, I'm going to grant your review, suspend the order, and then go and fix it, because everybody was happy with these, but go apply your discretion you now know you have, and let's move on and avoid any disruption. It seems quite likely that's going to be the outcome. Which leads me to the 5th point, which if there is a review, we've got to consider the remedy, and what is there a review of? So there might be a review of the designation, there might be a review of the decisions taken by the JSC, and the decisions of the president to appoint. But even at that point, we know from the Cape Bar decision for example, that even if you say the proceedings of the JSC were unlawful, that doesn't mean that the appointments of the judges that followed was unlawful. Because in that case, there was a review of a decision with regard to the Western Cape High Court, at which certain judges were not appointed and Judge Heney was appointed. And the court said, yes, we're declaring this meeting invalid. Judge Heney's appointment remains valid because nobody's asked to set aside his appointment. And so what would have to happen for there to be any actual risk? Because the risk we're talking about here, if we're going to be honest about it, the risk is down the line, judges who are appointed might have their appointments set aside. And that risk is so minute, because even if you get to that point, you have to review not only the meeting, you have to review the appointment decision. And what court is going to actually set aside the appointment of a judge because of this kind of technicality? The risk is, I would say, close to zero. The sixth reason, my lord, is that this isn't raised in the letter that MK writes to the JSC. The issues that are raised in the letter are Dr. Klope needs to be able to participate, and if he's not there, the proceedings will be invalid. And then, as Mr. Mainecha pointed out, there's a vague indication that the 18.2 may or may not suspend the proceedings, we're not sure. Suspend the order, we're not sure. This point is not made in the letter. So it's not something that the JSC did or could have directly considered. And maybe there's a good reason it wasn't made, because it's not a very good point. My lord, I finished this section. I see it's 1 o'clock. I don't know the court wishes to take a lunch adjournment.
Would you like to carry on until 1:15 and then have another quarter of an hour at 2 o'clock?
I'm in the court.
I'm just keen to get back a tiny bit of time we've lost. Let's carry on until 1:15.
I might finish by 20 past.
Let's see where we are at 1:15.
So the second issue is the participation of Justice Klope. So the argument here by the applicants is that if Justice Klope is not on the JSC on Monday, then the JSC will be acting unlawfully, and anything it does would be unlawful. And so you should postpone until he can participate. It's very interesting, as Mr. Mainecha again pointed out, that the relief sought is not Justice Klope must participate. The relief sought is don't do anything because he can't participate. But the argument is obviously bad for two reasons. The first is that the Western Cape Full Court has held that it can proceed. The point of the urgent proceedings, and this was abundantly clear in the papers, was abundantly clear to everybody who was in front of the Western Cape High Court, was that the applicants wanted the proceedings to go ahead next week, but we wanted them to go ahead without Justice Klope. That was the context in which the decision was taken. At paragraph 45 of the judgment, what the full court says is, during the intended sitting of the JSC, interviews for the position of Judge President of the Western Cape Division will take place, in addition to vacancies for the Supreme Court of Appeal and other divisions. Any participation of Dr. Klope in these interviews, it was argued, will undermine the integrity of the JSC and the public perception of its ability to perform its constitutional function. So our concern was, we want these to go ahead, but if Dr. Klope is there will be the real risk. And that's what the court ultimately upheld. And then in paragraph 68, the court said, in granting the same, the JSC will function in his absence, but if required, the NA may always designate another MP nominated by the opposition party to take his place. Irreparable harm befalls neither Dr. Klope nor the MK. So it says expressly that the JSC will function in his absence. Mr. Mainecha also took this court to paragraph 56. I'm not going to take you back there, but paragraph 56 of the full court judgment really makes the same point and shows that it considered the composition issue. It refers to the Premier of the Western Cape judgment. And it said, yes, despite that, there's no difficulty with composition. And the only argument I heard my learned friend Mr. Mpofu make in response to that is, well, the court said quorum, not composition. But that's an error of linguistics, not an error of substance. It was absolutely plain to the court what the issue was, because it was argued by, I believe, Mr. Masuku and Mr. Katz before the High Court, this precise issue, that Mr. Klope had to be there, otherwise there would be a composition problem. And we know it's a composition problem because the court refers to Premier for Western Cape, which is a composition case. Oh, sorry, I'm getting my wording wrong. It's an attendance case, not a composition case. We're beyond composition. It's an attendance case. So it's not open to this court to reconsider what the full court found. It's binding on all the parties here. And that should be enough. It so happens the full court was correct. And we know it was correct because of what the full court of this division said in the Klopper case. Paragraph 39, Mr. Mainetto read it, I'm not going to repeat it. But it's crystal clear that when there are justifiable reasons for the absence, the JSC can continue, even if some of the members of which it is composed are not present. And so what Mr. Mpofu argued in response, to say, yes, but you must look at the SCA cases, Cape Bar and Premier Western Cape, and you mustn't look at the full court decision in Klopper. That's wrong for two reasons. Firstly, because what the full court does is interpret the two SCA decisions. It refers to them in detail, and this court, as a single judge, is bound by their interpretation of the SCA judgments. It's not permitted with respect to go behind that interpretation and say, you were wrong in how you interpreted the judgments. But in any event, those cases say exactly what the full court says they say. There was a claim made that one of the members of my client, Ms. Helen Ziller, was flip-flopping because she was at the stage the Premier of the Western Cape, and she was making complaints about composition, and now she has no complaints. But it's important to go back and look at what happened there. What happened there is the issue the JSC was considering was the removal of Dr. Klopper, then Klopper JP. And Ms. Ziller, the Premier of the Western Cape, was not even informed about the sitting. So paragraph 4A, she was not present because the JSC had not notified her when and where the meetings were to take place. And she was unable to comply with her obligation to attend as required by section 178(1)K. So it's in that context in which the decision is taken, where you refuse to invite somebody. And the whole debate there was only about whether a Premier is required only for appointments of judges to that division or also for removals. That was what the case was about. It's interesting, at paragraph 21 of the judgment, the SCA says there was another potential difficulty about another absence. It says the Court of Quo also found that the JSC, again on its own version, was not properly constituted, and that one of the practicing advocates to be appointed in terms of section 178(1)E had not been appointed by the President. The point adds little to the previous one, and I prefer to leave it open, especially in view of the fact that it is not known why the advocate had not been appointed. So it's clear then that there's also an issue of, well, what is the reason why this person is or is not there? And then if we look at the Cape Bar case, the relevant paragraph is paragraph 36, where the SA says, I therefore agree with the Court of Quo's finding that in the absence of the President of this Court and his deputy without justification, the JSC was not properly constituted. So not only is this court, like the full court in the Western Cape High Court, was, well, I'm not sure it was bound, but it followed the decision here in Klopper, but they were correct in their interpretation of the two SCA judgments. So those are the two main pillars in this case, and they both fall completely flat. There's no merit to them whatsoever. And they created no meaningful risk for the JSC that would have justified it saying, because there's some remote possibility that sometimes somebody might bring a review of something that may or may not be unlawful, that may or may not lead to a remedy that impugns the decisions we take, we're going to waste 3 million rand and leave our courts unstaffed for months and months on end. And that's the rational thing to do, because that's the applicant's case. That brings me to section 18. And the first point is that this really, whether the decision of whether the applications for leave to appeal suspended the operation of the full court's order doesn't matter. And it doesn't matter because the result of suspension would be that Dr. Klopper would be entitled to attend. And that's never been the demand, and that's never the relief. That wasn't the demand made to the JSC, and that's not the relief they seek now. And so it's really an irrelevancy whether it's been suspended or not. So if they were correct that the judgment has been suspended because of the applications for leave to appeal, what it would mean is that Dr. Klopper is entitled to appear on Monday and say, I'm entitled to sit here. Not that the JSC shouldn't hold any interviews. But the second issue is, even if it does matter for some reason, we submit obvious that the decision falls under section 18.2. But it is an interlocutory decision that does not have the effect of a final judgment. And I think it's important to distinguish here between questions of appealability and the question of the application of section 18.2. Our law on the appealability of interim interdicts is, I think, somewhat contested at the moment. And whether the test might be different in the Constitutional Court versus the Supreme Court of Appeal versus appeals from the Magistrates Court. When can you appeal even if it's not final effect, if it's in the interest of justice? There's, as I read the law, some confusion on the issue.
Yes.
But
I mean, Zwini's a good guide to finality, isn't it?
Zwini is a good guide to finality, and that's the question.
And the problem that you're setting out is that finality and appealability have been separated from each other.
Yes.
We just don't know how separate and in what circumstances.
But what we do for section 18.2, because section 18.2 is a statute that tells us.
Yeah.
And so that the test is there.
Yeah.
Does not have the effect of a final
For purposes of interim effect, yeah.
For the purposes of interim effect. We don't have to worry about...
But Zwini's still a good guide to whether an order's final or not.
Yes.
Yeah.
But the interim interdicts have always been regarded as interlocutory orders that don't have a final effect. And that's so for very, very good policy reasons. Because otherwise it would be a waste of time. Because I would go to court and get an interim interdict, normally sought in urgent proceedings, to preserve a position or alter a position for a period of normally months until final relief in an action or review, whatever it might be. And if that could be undermined by simply lodging an application for leave to appeal, and then losing it, petitioning the SCA, losing it, petitioning the Constitutional Court, and that process inevitably takes up to a year, it would be an automatic right, effectively, of any litigant to suspend the operation of any interim interdict simply by pursuing their rights to appeal. And that's why section 18.2 says what it says. Interim interdicts would be rendered nugatory if they were not, if they were suspended by the lodging of an appeal. There will be the rare case where an interim interdict is final in effect, because by the time you get to the review will be moot, or by the time you get to the action. Cronshaw is an example. This case is an example. If this court granted the interim interdict in this case, and we treated Part BB as a review, by the time we get to the review is moot, because the postponement has happened as by dint of the interim interdict. It would be of academic interest only, the review. So if this court was minded to grant the interim interdict, there would likely be an appeal, and it would be final in effect, which would suspend the operation of the order. But that's an unusual case, because of what is being sought to be reviewed is the postponement which will be achieved fully and finally by the interim interdict. But the decision of the full court is not like that. The decision of the full court leaves Dr. Klopper as a designee to the JSC. He's still a member of the JSC. And it lasts only for until all it says is you may not participate until the review is determined. It's always the case that interim relief has a final effect during the interim period. That by definition, that's what it's meant to do. That doesn't make it final. If we say that is final effect, every interim interdict is final in effect. And that's never been our law.
Well, the question is whether it meets the three tests for finality. It disposes of a substantial part of the relief claimed, is definitive of rights. Not just that some things can't happen that would happen without the interdict.
Exactly.
Yeah.
And ultimately the rights that are at issue is, was the National Assembly's decision to designate Dr. Klopper lawful or not? And that is an open question that has not been determined between the parties, and will only be determined when the court determines Part B. That's the substance of the dispute. The Part A dispute was, well, what should happen until that substantive dispute is decided? Should he come or should he go? Should he be on the JSC or not? And that's classic interim relief. So we submit for those reasons that the section 18.2 point doesn't get the applicants anywhere. My Lord, I'm almost finished. If I might have another few minutes, I think I can wrap up in the next 3 or 4 minutes.
Yeah.
That brings me to the requirements for interim relief. So just to take a step back, the primary relief sought is what is really the review of the postponement. It's called a declarative, but it's a review. It's quite strange, and it's final relief. It's quite strange to say, I want final relief. In the alternative, I want interim relief. Because if you lose on the final relief, how can you ever get the interim relief? because the court would have made a decision that there is no right.
Well, I mean, that's why I had the exchange with Mr. Mpofu I did. There are two different bases. The first is the rationality of the postponement. If it's irrational, that's a final declarator. In relation to the interim relief, it's the constitutional rights, mostly the Section 19 rights that the applicants say they have in these circumstances.
Yes, so I think as I read it, there's two bases sought for the interim relief. The one is the prospects of success in the review that's going to be in Part B, but if the court refuses the declarator, there cannot be no review. The other is the various rights that are asserted on behalf of Dr. Klop, on behalf of the National Assembly, on behalf of the JSC. Mr. Meinet is quite right that Dr. Klop can only, and the MK party can only assert their own rights. But with regard to that category of rights, that's been determined by the full court of the Western Cape. Because all these same arguments were made to that court. There was in the context of balance of convenience, Dr. Klop argued, you shouldn't preclude me from attending the sittings of the JSC because it will affect all these constitutional rights I have.
Yeah.
And the full court said, yes, we'll consider that, but we're going to preclude you from attending. And granting an interim interdict on that basis in this court would be to effectively set aside the decision of the full court. Because nothing new has happened other than the postponement decision, which is knocked out one way or another by prayer 2. And once that's either that they get that relief, you don't get to interim relief, or it's knocked out and therefore it's irrelevant to these other prima facie rights that are asserted. And that's the same case that was before the full court, just the other way around. That we were seeking to prevent him from attending and he's seeking to force his attendance. But the decision is the same. And the same goes for irreparable harm. That's also been determined by the full court. It says no irreparable harm will be suffered by Dr. Klop or the MK party. It says so in terms. On the question of alternative remedy, we've set them out. They can pursue their appeal, they can seek Section 18 relief in the Western Cape High Court, they can review the appointment of the designees, the 5 designees. And we also, we make the point, and we're going to stick to it, that they could have asked the National Assembly to designate a different member of the MK party to sit this week. This point was raised again in the full court in front of the Western Cape. The DA expressly said in its founding papers that if the relief is granted, the MK party will be entitled to go and ask the National Assembly, say, we want you to withdraw Dr. Klop's designation and designate a new person. And the National Assembly never said it couldn't do that. It was expressly put, it didn't say, no, we can't do that. It didn't say, no, we can't on functus basis. It didn't say, no, we can't on a timing basis. And we see no reason why they would be functus, because what you're doing is you're sending a designee. You can always say, well, I want to send a different designee. A party may say, well, yes, this person's B on the JSC. We'd rather now have somebody else. Please designate person B. And that option hasn't even been exercised. The MK party hasn't approached the Speaker and said, please, can we urgently this week try and send a new person, a new member of Parliament, so that we have representation on the JSC. They sat on their hands and brought this application instead. Lord, I was going to say something about remedy, but I think I've covered it in what I've said previously. On the issue of costs, we seek our costs. We seek the costs of 2 counsel. This may be constitutional litigation, but the applicant and the DA are private parties, not organs of state. BioWatch has no role here. It may with regard to the JSC, but not with regard to my client. We also seek punitive costs because we submit that this is an abusive application. It should have been immediately apparent that the full court has dealt with this matter and that the decision not to postpone was not a decision that could reasonably be said to be irrational in these circumstances for all the reasons I've given. It's difficult to understand in the way the case is structured, the way it was brought, why it really was brought, because the applicants never seem to actually ask for the relief they want, which is for Dr. Klop to be on the JSC. So we submitted it was an abusive application entitled to cost and attorney-client scale C. Counsel.
Well, if you want attorney-client costs, you can't have costs on scale C.
Oh, then you
Scale C applies to party and party costs.
So if
somebody wrote a judgment about that once.
I believe so.
Yeah.
But those are my submissions.
Thank you. It's just after 1:45. I am going to suggest that we adjourn until 2, and then we hear from Mr. du Plessis. Thank you. Court adjourns.
That's all I know. All this time, all this time.
I think the good time is a kid to find out what is that.
Interview.
Some follow the PWK line, some follow the Barsha, and I don't know. Are we gonna?
I need your boss.
We got
I'm not sure. Okay, let me take my there's nothing. I thought I would stay here. I'll take this one.
No, not quite. Well, you guys are free segment. I'm not sure. Thank you very much. Are you switched on X?
Yeah, I know. La meta la estaba mirando. Le van a luchar.
I heard your comments. I thought it was brilliant. I heard your comments. The way you dealt with the awful was to say, I understand your point. So what I needed to do, instead of brief.
Are you switched on X?
Yeah, I could see you.
Okay, let me have shots.
Do you have another power bag? No, I just
Yeah, it's on a bike. They want to come to me after the bags. Guys, can you see me? Hello? Hillary? Hello?
No. Yeah, right now.
Hello? Gallery? Hello? Woo. Yes, guys, like how much longer till you come to us? We want to eat. Yeah, I can hear him now. We're good to go. Yeah.
And then after
No problem. Copy.
I mean, if I don't play the game, man, I'm going to be able to do it. You can better out finish than you can't do this. Or no. You're going to be late to talk with us.
That's right, Michelle, and they're basically saying that they are bound by that court order that was handed down on the 27th of September, and that they can't deviate from that because that particular judgment does deal with the consequences of Ethiopia's absence, including any possible constitutional implications, as was argued by Daniko earlier on this morning, that Ethiopia's personal, political rights would be trampled on because, in essence, the Western Cape High Court did not terminate his membership, but he's now not being allowed to exercise the political right given to him as a designee of the National Assembly. But another argument that has come both from the JSC and DA is that, well, the interim relief that is being sought by Daniel Mpofu and who's representing the MK party and that of Dr. John Lopez, they're not arguing per se or directly to have Lopez be the one to attend the sitting, but instead they've chosen to argue against the postponement of the entire sitting. And that's when the DA's lawyer, Michael, then came in there to Michael Bishop, who came in to say, well, the concept of balance of convenience now comes into play, where the JSC has to consider which aspect or who would be most inconvenienced. Do you go ahead with the sittings without Dr. John Floppe as contemplated by the Western Cape High Court, or do you allow Dr. John Floppe to come in and participate in these sittings, and then part B, which is looking at his designation and the rationality of that decision, if they come back and say, well, actually, he shouldn't have been part of that, shouldn't have been part of the designees to the JSC altogether, then do you go back now to the judges who will be hired after this process and say, well, now your appointment is now irrational and unlawful? And so the DA's lawyers are saying, well, the JSC would obviously have chosen for the first option to go ahead with the sitting without the presence of Dr. John Floppe. So these are the arguments that we've heard so far, and insofar as the relief then that is being sought, for example, by the MK party, the DA's also argued that why hasn't the MK party, instead of pushing for a postponement of an entire JSC sitting, why have they not opted to instead go to the National Assembly and say, well, look, our current designee has been barred by a court order, can we not replace him until such a time, the full judgment is handed down? And they say, well, we don't even know what the National Assembly believes because the MK party has chosen not to take up that option either. Thank you. Next. Go. I'm so hungry. So they don't allow food inside the books?
Some people know how to put it in plastic.
I'm not put it in my bag.
Yes, we hide it in the way that the...
Do you not want this now?
No, this one don't have this. So
That's fine. It's just too
Okay.
Let's go, X.
you guys caught
You're telling me to you don't quote you on.
No, but you know, it's
We have
actually
past two.
very good. I'm not even going there. I'm just going, like, I'm chill. Just
Don't go in on my
corridor.
side.
What happened? I call it up the
Leave
pharmacy.
the X.
Which is there?
Oh, ex-men, go pick up Kelitos, whatever you write. But I said, I'm hungry. I'm not back up on the job.
I need to charge my stuff even. Or can't you just go to McD and get like a junior cheeseburger and just hide it in the chicken? No, it's not. McDonald's is on the road. You don't have to drive. Yeah, there's even like a deli, so I'm sure they have like a rack you can just hide in the thing. Shut up. Shut up. finishing the filing and then I'm going to charge my laptop there. Thank you.
Get your fruit.
Hey? Eat your food.
Colin's right now, dressing to me.
And then what I feed him. The problem is he doesn't feed her.
This is the first time who's gone into court with food. Really? Yeah, I've never heard of it.
No, but I share like, who's going to eat the food?
Oh, she would. Oh, who's gonna do that? You? Let me go out. I don't know why they can't even switch it off, like even
Look at this.
like just for
I
us
think the
to.
switch is not.
Man, can't you ask her?
What's
You
that?
greeted that lady so nasty. Can't you ask her?
Which one?
The lady who's sitting there.
Oh no, I was greeting to me for the clerk.
Yeah,
I don't-
can't the clerk help?
I didn't walk in, it was like this. It must have been
I feel like it's gotten worse.
like my father's didn't come outside and I didn't charge it for him.
No freaking words. I don't think I need to. I think our stuff is safe.
Yeah, same here.
This is the last court, so I mean, I'm outside on the benches. I'm watching.
No, you're right, it's fine.
Oh, flipping hell, no, man. Yo.
Mr. Monzi, you can just put it in your jacket. Like, just walk a little bit. Gandhi, what is it? No, you don't need to buy chicken, you just buy a wrap. They do. This is Galito's, right? Oh, no, Colin. Yeah. Must I bring the hand down? Yeah, I thought I was on a church. Phone, but okay. Yes, I have. Okay, sure. Okay, sure. Pleasure. Pleasure. Will you just give it to me? I'm not out of that one.
Half an hour.
Yes. You still have 10 minutes. For 10 minutes. Sure. Oh, occupational thing, yeah. Yes, yeah. Those ones, yes. And all we want to say is about
Still going to push ahead with that review of the JSC Unterhalter decision. Don't know, honestly. It doesn't seem like it needs to, right? Well, that's yeah, that's right. There was this promise that the JSC fix.
Yes.
And they would call public comment.
Yeah. Did they? I don't know.
No, I don't think they have.
Maybe I'll do it this time.
So,
Is this their next big meeting? I'm not sure.
Yeah, I don't know.
The reason why I'm questioning them is otherwise I always have to for your argument.
I won't have a butter biscuit. Give it to Dolly.
Yes.
Take mine.
Okay, thanks, Matt.
Tell Weber's and Bones they need to up their game. Snacks.
I think it's more cigarette.
Norton's is the gold standard.
Yeah, exactly.
It's actually Nina that's the gold standard.
Yeah.
Nina and Mandla. Mandla came in this morning acting as the advocate with a robe.
Mac,
Stashed with good.
have you seen this? The judiciary.
I don't want to do anything. I'm using Dolly's words.
Yeah.
I just follow my client's instructions.
You just what's it called? Missing out. Whoever pays. Okay, yeah. Yeah, this week. And I hope it's over. Sure. Even for me, this was.
I'm sure you were going to say there's nothing to reply to.
Yeah.
I mean, where is
No, so far.
So far.
Let's see how next week.
Yeah, next week is our only hope.
Yeah. The last hope.
He's our only hope.
The last hope. But now we just go home.
We've made all the submissions we needed to hear today.
Yeah. In support of my case.
Supported your case.
Every day. Day and night. It should be a night video. By the time your thing came about 7,
Yeah.
that's when I thought there might be a chance to keep at midnight. I think we must yes, exactly. Like limited 4 a.m. Yeah. In fact, what we do is we can send it at 4. Yeah. No, it was like this with those elections.
All right, then, Clive.
Yes, Mr. Du Plessis.
Thank you, my Lord. My Lord, I'm going to be dealing with 3 topics, and in some respects I can be obviously much shorter than my predecessors. The first topic is to explain to my Lord why there are no rights that have been shown by the applicants to justify their relief, no rights that, in other words, justify their declaratory stroke review relief, nor rights that justify their alternative interdictory relief. I'm then going to turn, my Lord, to look at constitutional harm, which Freedom Under Law submits has been somewhat glossed over to this point. There are very important features of this case which my Lord would take account of in any exercise of judicial discretion. And related to that, and then the third point, my Lord, is finally the question of costs. And I'm going to be dealing with that in the context of scandalizing statements which have been contained in a media report by the MK party. My Lord, let me start then immediately with the issue of rights. We have listened to the debate, and it really now seems to be common cause through my Lord's questions that the issue is the right to a rational decision, whether that is something the JSC rationally exercised when it decided to refuse the postponement. Lord, we say that the JSC was, Mr. Menetje says, correct. We say it was not just rational, it was perfectly rational in doing so. And my Lord, we say that because it had been confronted with a question about Section 178 and composition. That is set out in the letter by MK's attorneys that was written to the JSC in justification for the postponement. And I'll take you there in a second, my Lord. And the response to that was the reasons letter that we've already looked at by the JSC. Again, I'll have to quickly take you back to that. But my Lord, let me just immediately say that in any event, my Lord's point right up front is that all of this is an irrelevancy. This debate around composition is an irrelevancy in light of the fact that it misses the point. Because as my Lord put it, I think it was to Mr. Mpofu, the JSC is bound by the brute fact of there being an order of a court. That order of the court, it said that Mr. or Dr. Schloppe is not permitted to attend the JSC's meetings next week. But, my Lord, let me take you down into the debates, because we've had the benefit of those debates a couple of weeks ago in the Western Cape High Court. I can therefore give you, my Lord, an explanation for why what is in the Western Cape High Court's judgment is directly related to this very debate of Section 178. So, my Lord, let me take you, if I may, to the JSC's letter. And that letter is MM5. My Lord, we looked at it earlier.
Yeah.
And my Lord, you'll see that the JSC says that it had an urgent meeting, and it was noted, these are its reasons as we've been describing them. The judgment of the full court did not set aside the decision of the National Assembly to designate Dr. Schloppe as a member of the JSC, and does not therefore impact the composition of the JSC. My Lord knows that. whether it's a question of attendance or quorum or composition, that's how they understood the point. One can have a quibble about whether it's the right terminology in law, it doesn't matter. The point is they understood that was the issue. And then they said the JSC thus remains lawfully composed in terms of, and importantly, my lord, section 178 of the Constitution, and there's no violation of section 171H. They go on to say at the top of the next page, while the full court has interdicted Dr. Hlophe on an interim basis from participating, it expressly found that his absence would not render the JSC's decisions or processes unlawful. So, my lord, they knew that the issue of composition and the interpretation of section 178 of the Constitution was the issue that they were responding to. And, my lord, it's not the case, with great respect, that that letter was what excluded Dr. Hlophe. It was the court order. That's why they were talking about the court order. The proximate cause is wrapped up with the court order. We can't separate the letter from the court order. And, my lord, the JSC looked, therefore, at the interpretation and the composition point. We know that from their letter and their reasons. And Mr. Mpofu, my learned friend, repeatedly said that this case is about interpretation, and that includes of section 178. And, my lord, the predicate for his relief, for our learned friend's relief, is that section 178, properly interpreted, means what? That the JSC is not properly constituted without Dr. Hlophe being present. That is the predicate for their entire case today. And, my lord, our learned friend, Mr. Mpofu, said to us that we didn't understand his case and that the respondents were, unfortunately, misinterpreting his case. But with respect, we haven't, because if you look at the founding affidavit, paragraphs 82 to 83, I'm afraid to say, my lord, in my hurried printing off, I didn't get the case lines version.
It's all right. Founding affidavit, paragraphs 82 to 83.
Yes, my lord. So here you've seen, just before that, just so that you can go back, you'll see they are saying various things about what their rights are. And here, my lord, you'll see at the top of the page, paragraph 79, they talk about section 34, then they talk about section 36, and then section 19. But here, my lord, is the heart of their case. They say, most crucial, and in addition, the conduct is inconsistent with the clear provisions of section 178(1)H. More particularly in that, the forced absence of Dr. Hlophe will inevitably result in a major disturbance of the delicate balance intended to be achieved by prescribing that split between members of the ruling party and the bloc on the one hand and members of the opposition parties on the other, and the composition of the JSC as described by the constitutional drafters will therefore, or thereby, have been defeated, which is inconsistent with the relevant provisions of the Constitution. So, my lord, that is their case. They say, most crucially, that's their case. And we've understood their case as that. The JSC understood the letter and the complaint as that. The JSC responded to it by saying, we've thought about it, even read and we've decided that the meetings must go ahead, even though you ask for Dr. Hlophe to be there. So, my lord, the problem is that for our learned friends, is that the interpretive predicate of their argument today about section 178 is the same interpretive predicate that was advanced with trenchantly, I may say, and at length in the full court a couple of weeks ago. It was exactly those arguments. We were in those courts. Mr. Moneche wasn't. He wasn't because the JSC had abided. But I can tell you, my lord, Mr. Bishop and I were there, and those were the debates, the very debates that are now the same debates that are being relied on to animate for the relief sought today. So, my lord, in that context, let me then say that there are two judgments, they've been referred to by all of us, which put the debate to rest as to whether it would have been rational for the JSC to consider that interpretational debate of 178 and come to the conclusion that we can't allow him to be there. It doesn't matter if he's not there, it's still composed, and it can still proceed in his absence lawfully. And, my lord, those judgments, the Lord knows, it's the JSC decision, rather the Hlophe decision versus the JSC by His Lordship Mr. Justice Sutherland, Victor and Ledwaba. And Mr. Moneche read to you, my lord, from paragraph 39. And then you heard from Mr. Mpofu saying that the SCA Cape Bar Council is binding. And we also heard him saying that it has been binding because of its interpretation of the various provisions. But, my lord, the interpretation has been done, and it has been interpreted by the full court, which with great respect is binding on my lord, in relation to these very provisions. And I want to just please, with my lord's leave, read to you paragraph 52 of His Lordship Mr. Justice Sutherland's judgment. I can't remember if it was, with no disrespect to either Justice Sutherland or Justice Ledwaba, whether it was Justice Ledwaba's judgment, concurred in by them. At paragraph 52, and we've heard our learned
Judgment
friend,
of the court.
yes, a judgment of the court.
Paragraph 52.
Paragraph 52.
Yeah.
The court has looked at all of these debates, the ski road cases and new clicks, and it's looked at composition and attendance and quorum. But what is the principle of the case? The court comes to express a principle, which is the principle at the heart of this case. It's what Mr. Mpofu, our learned friend, says is about interpretation. He kept telling us this case is about interpretation. Well, let's see what the court said. It said at 52. And that goes to our next point, the need to avoid paralysis of the JSC. We are enjoined by the rules of interpretation not to interpret Section 178 in such a way that results in the paralysis of the JSC if a reasonable alternative construction is possible. Paragraph 53 goes on. So that is the interpretation that was advanced and accepted by that court, in contrast to the arguments that have been made on behalf of Mr. Schlopper, or Judge Schlopper as he then was. And that interpretational argument was ultimately resolved against Dr. Schlopper as he now is. And it was resolved in those terms by the court. So the full court, my lord, has ruled that one has to avoid paralysis by the JSC, and that you have to avoid paralysis by an interpretation that avoids the impossible. And Dr. Schlopper's arguments today, with great respect, my lord, seek to paralyze the JSC. Not, as Mr. Bishop pointed out, not to seek an order that he can return to the JSC, but that the JSC en bloc cannot sit. And my lord, that is paralysis exemplified. And in that context, my lord, you've got to ask this question. The JSC knew that the request that was being made of them in the letter by Dr. Schlopper and the MK's attorneys was to effectively have paralyzed the next week, and who knows for how long. And they looked at the interpretational points. They say so in the letter, 178, and they said, we're going for a different approach. And then the only question from the Lord is it a rational one? And we would say with great respect, of course it has to be rational. They've got in their favor the judgments which I've just highlighted for my Lord. They know that these very arguments were debated in the court at a full length. And they know that the court ultimately came to the conclusion, as it did in paragraph, I think it was 56 that everybody's read from the Western Cape judgment more recently, where in the end the court said at paragraph 56, I think Mr. Minetti quoted it, the absence of Dr. Schlopper on the JSC would not be significant. There would still be 5 NA members represented on the JSC, constituting a majority of such members. That's the point. So, my lord, the first point we can summarize is the following. There would be, through the interpretational arguments that our learned friends for the applicants propose, my lord agreeing with them and paralyzing the JSC against the binding authority that I've highlighted for my lord. But my lord doesn't need to be concerned about that, because the only question before you is the rationality of the JSC's decision in any way justified? And for all these reasons, of course, it has to be justified. It would have been thoroughly irrational for the JSC to have done the opposite. My lord, just posit this. The JSC says, thank you, we take your letter. We know we've spent all this money. We know all these people are coming. We know that there is a huge demand for judges to be obviously appointed to ensure the backlogs in the courts are fixed. We know all of that, but we're going to nevertheless adjourn. That would have been thoroughly irrational. So, my lord, with great respect, there are no good reasons that have been advanced by our learned friends. There is a second point related to this, and it's the question of jurisdiction. We say this with respect to my lord, but until Dr. Schlopper obtains a court order overturning the interim interdict that has been granted by the Western Cape High Court, until he obtains that order overturning it, or he wins on appeal, or he wins in Part B, he is interdicted. Full stop. My Lord's point is the brute force of that order. And he cannot seek from my Lord to undo that order, because it's binding on him and it's binding on my Lord. As an order, orders of courts bind everybody. They bind my Lord as well, section 165.4 and section 165.5. So my Lord, if he wishes to undo that, he has a remedy. My Lord doesn't need to feel as though you've locked him out of court and that section 34 rights have been violated. His remedy lies in section 18. He can go to the Western Cape High Court, the court that granted the interdict against him, effectively, and say and immediately allow for that order to be suspended, if that's what he wants to do. There's been a debate about 18.2, 18.3, my Lord. I don't want to take you back to that, other than to highlight the following, because again, our learned friend Mr. Mpofu said that we've misunderstood his case, and that clearly they don't need a section 18.3 remedy, because just by having applied for leave, it suspended the operation of the order. But my Lord, that's not the position from their own letter. And some of it was read to you, but I need to take my Lord to it. It's MM3, it's the letter by the attorneys.
Yes,
you have it, my Lord.
Yep.
And if, my Lord, if you go to 02-121, paragraph 5. Now, these are the attorneys that are writing to the JSC, trying to explain to the JSC why the JSC must postpone next week's meetings. And look at what's said at 5. There again, at 5, they raise the 178.1H argument, my Lord. No debate. They are wanting to retread those arguments. Second, my Lord, it says, the undesirable situation is exactly what will obtain unless before 7 October 2024, Part B of the High Court application or the Africa Forum application pending before the Con Court is heard and decided. That's gone away, by the way, my Lord. The Constitutional Court has said no. Or the National Assembly designates another person, assuming that it's constitutionally possible to do so, which they deny. And then the outcome, my Lord, of any application for leave to appeal and or proceedings in terms of Section 18 of the Superior Courts Act. Lord, on their own letter, they explained that they knew Section 18 was where they would be able to avoid what they said was that outcome. So, my Lord, that's the Section 18 point. We've understood perhaps Mr. Mpofu's argument incorrectly, but that is what his client's letter said through the attorney. So, my Lord, let me then next say on jurisdiction that there is an insuperable further difficulty for our learned friends, and that's the judgment of His Lordship Mr. Justice Olson in my division, my Lord, in Durban, the Aqua Transport. My Lord, in that case, there had been a review, and excuse me, there'd been a review, it had been successful. There'd been a decision to apply for leave to appeal against that review's decision. There was then a separate case which was brought for an interim interdict. So the review had been before His Lordship Mr. Justice Lopes. There was a separate case brought for an application for an interdict, but like before my Lord, for an interim interdict pending the outcome of that appeal. That is effectively what His Lordship was dealing with in that case. And His Lordship Mr. Justice Olson refused it on the basis of the analysis that I don't know if you've had time to have a look at, my Lord, but it's in our heads of argument. I'd ask you to take a bit of time there. It's a paragraph 25 of the heads of argument that Freedom Under Law filed.
Yes, thank you on that.
So, my Lord, if I can just take you to the paragraph before that, because that it's situated. Olson J. refused to do so on the basis that, given the extant judgment against the applicant failed to prove any right to the interdict. He explained, I find it difficult to conceive of a circumstance which throws more serious doubt upon a claim that prima facie proof of the existence of a right has been established than the fact that the court has already adjudicated, in that case finally, upon the matter and determined that the right doesn't exist. But then, critically, next paragraph. Having made those observations, I still find myself in difficulty with the proposition that this court, sitting otherwise than as an appeal court, has the power or discretion in effect to overrule, or at least to second guess, a prior decision of this court in order to grant a temporary interdict pending appeal. And he said he wants to turn his face against that. Why? Because a practice or procedure which involves, like my Lord, another judge, deciding the quality of prospects on appeal before the judge who heard the main case has decided whether the threshold of reasonable prospects of success on appeal is met, undermines Section 17 of the Superior Courts Act. He says that section carefully reflects the balance. And then you'll see the bolded point next. In my view, unless the application for the interdict is brought before the judge who made the decision subject to appeal, a glaring error on the part of the original judge must be apparent in most cases before interim relief is granted. Otherwise, there'd be nothing short of a whole re-hearing that would be required. My Lord, as we say...
Nothing in this case requires me to go into the full court's decision-making or criticise it or approve it in any way.
No,
and the question is, what is the effect of the order?
Yes, yes, but in order to get to whether the order has that effect,
there
is the debate about rationality.
Yes.
And that debate engages the very debates.
The question of rationality is, did the JSC properly apprehend the effect of the order?
Yes, but in order for that to be answered, then we get back to the debates about whether it was properly understanding the interpretation of Section 178 and the debates that we've been having about those judgments.
I'm not sure that's right. I mean, the fact of the interpretation is different from its correctness.
Yes.
So if one, the question is, there's the decision of the full court. Its order has to be interpreted in light of its reasons.
Yes.
Those reasons are presumed to be correct.
Yes.
In order to interpret the order.
Well, my Lord, you've put it perfectly. Except you are being asked by the applicants to presume that it is not correct because of their arguments, which are the very arguments that were raised by them there but rejected by that court. That's the conundrum. So, my Lord, the moment that position is clear, that my Lord accepts the reasons as being correct and that those reasons justify the order, then there's no room, and this is the point. It's the same point with great respect that Justice Olsen was, I think, putting. There's no room for another court to have to go through that process.
As I understand the applicant's case, their case is there are two ways the JSC can comply with the order, a rational one and an irrational one. They say the rational one is to postpone all proceedings until the interim order is confirmed or discharged. JSC differs. That's the terrain on which we're having the argument, I think.
I think that's correct.
Yeah.
And for the reasons that I've given, my Lord, if that is the approach, then these are the other difficulties, if I may say. My Lord doesn't need to get into these difficulties, but they arise unless one focuses on exactly what my Lord has said.
Yeah.
That's with respect.
Given the time that I have to decide this case, I think the shortest distance between 2 points is a straight line, isn't it?
Wilson's razor, my Lord.
Sorry?
Wilson's razor.
Yeah. Well, I mean, call it what you want, but it just seems to me that I have what's been placed before me is a very narrow question of whether or not the JSC rationally exercised its power to refuse to postpone next week's and I think the week thereafter's interviews, and that narrows down the focus or the squint with which I must regard the full court's decision.
Yes.
The decision is not a disquisition with which I have to have a Socratic dialogue. It's just a fact. It's just there, and I must and I must put myself in the position of the JSC when it had regard to the fact of that decision.
Absolutely, and my Lord, the question of whether the JSC's rationality arises from its understanding of what the court had decided.
Yes.
In light of the debate around 178.
Yes.
My Lord, we're on the same.
I mean, of course, if the case was that it completely misconstrued what the judgment and the order meant.
Sure.
But that's different from disagreeing with it, or criticizing it, or affirming it.
Yes. But a component of the rationality, and this will be my last submission on this, is whether it was appreciating what the alternative arguments were, and they are there in the letter. They knew it had been debated, and it was then asking itself, well, what is the alternative?
Yeah.
And that is the debate that it ultimately decided on a rational basis was in favor of effectively agreeing with the interdict. So
Yes,
my Lord,
I have that point. Yeah.
Yes, my Lord. So then, in that context, my Lord, we say that the next important issue for my Lord to consider, and I needn't be long on this at all, is constitutional harm.
Yeah.
And I don't need to be long on it because my Lord has written the Nyazi Rail judgment, and we are aware of that.
Yes.
And we've cited it for my Lord in the heads. But, my Lord, we see the constitutional harm as being particularly important. It goes, we heard the debate with our learned friends, and we agree with you, my Lord, it's the debate about where this constitutional harm fits. And it fits in two ways. It fits in, if it's an interim interdict, of course it fits in there at the outer level. But it also fits into the debate, we agree, on what is a just and equitable remedy if, my Lord, were to have to go there.
Yeah.
So, my Lord, we say that there are, we've identified 5 harms. The first harm is a critical one, is that it's the rule of law itself which requires, obviously, that the judges be permitted, or the JSC rather, be permitted to fill the spaces, not just for the sake of filling spaces, but in order to ensure the constitutional end itself of the Bill of Rights being protected by judges who fulsomely are able to do so. The second harm, obviously, is for everybody that's having to come there but now can't, from the Chief Justice to the judges, president, and so on. The third harm, my Lord, is, of course, the public resources that have been squandered. And the difficulty of trying to have these meetings. It takes months to set them up. We've heard the argument from our learned friends, but it can be done just another 2 or 3 months and it can be sorted out. Well, firstly, that's not the relief they're seeking. But in any event, it's simply not appropriate. There's no evidence of it, but the public evidence that we're all aware of is that it takes very months. The fourth is the administration of justice. And here, just on the evidence, my Lord, there is an insuperable difficulty for our learned friends on constitutional harm. Because Dr. Schlopper doesn't begin to address the irreparable constitutional harm at all. He doesn't do so. Versus the evidence that you've got, we all referenced earlier Mr. Nkatobe's affidavit. But if one looks at that affidavit, he personally says, my Lord, that he collated the evidence regarding the impact of the interdict on the functioning of the courts, specifically the Supreme Court of Appeal, the KwaZulu-Natal Provincial Division, the Land Court and the Labour Court, by directly engaging with the heads of those courts. So my Lord has that evidence from him through those judges. And my Lord, it's not a case of him creating an extra reason. The reasons are given. The JSC is providing you an explanation for why it thinks its reason was absolutely right. And it had already said that it wanted to continue on this basis.
Yeah.
So, my Lord, those are submissions on constitutional harm, and they will weigh in the balance heavily, we say, with respect. My Lord, and then finally, on costs. And my Lord, we are not in the fortunate position of the JSC, who can be magnanimous, because, as you'll have heard from Mr. Bishop, the DA has asked for punitive costs, and Freedom Under Law does so as well, my Lord. And they've been scandalized in this case. Your Lordship knows that after the MK party and Dr. Schlopper were unsuccessful before the full court, they didn't seek urgent legal redress. Lord, what they did is they published the media statement. And that media statement, Lord, is for my Lord's benefit. It is 06235.
Yeah.
The statements that are made in there, my Lord, are scandalous, obviously, and they go to the very heart of the idea that the judgment is something sacrosanct and to be respected. And with great respect, we say that as a result, there are numbers of provisions of the Constitution which are immediately implicated. Not least of all because Dr. Schlopper is a member of Parliament, he's the deputy leader of the MK, he's the parliamentary leader, and of course, we know then that those obligations on him are 165 and 173 of this court's powers to protect itself from such conduct. And my Lord, the difficulty is that we're not making, it's not just the content, it's not just statements that have been made in that media statement. It's the fact that it's a continuation of the same conduct that has been deprecated by the Constitutional Court. And my Lord, in the answering affidavit by Freedom Under Law, but to take you there very briefly, it's at 06204, paras 27 to 28.
06204.
Yeah.
Yeah.
What happened there is, as my Lord recalls, the contempt case, and then after the Constitutional Court issued its judgment, statements made by Mr. Zuma. And the Constitutional Court said those media statements were put before it. They were recorded that it was admissible evidence, and it said this at paragraph 27. If the publication of these statements had no relation to him, he could have provided an explanation, either publicly or in these proceedings. He didn't. He even had an additional opportunity to dispute his connection to these statements after the hearing of the matter. However, to date, he has made no attempt to distance himself from those statements.
There's a letter asking, I think, Dr. Schlopper and Mr. Zuma to disassociate themselves from that press release, is there?
There is, my Lord. So there was a letter written by my clients to their attorneys, the attorneys for the applicants, saying to them, this is a statement that's been put out. It says these things about this judgment. And we would want confirmation as to whether you associate yourself. Now, my Lord, what you have, and in light of that passage I've just read to you from the Constitutional Court, saying, you have the replying affidavit that was filed and that came in, I can't remember if it was at 12 o'clock or 2 o'clock this morning. Paragraph 31
I've already made clear what I was doing at 2 o'clock in the morning. Yeah.
Paragraph 31 of it, my Lord, says this. So, my Lord, there's a further waving away of this. It says the long diatribe. It was a long diatribe. It just happened to be a very long statement. The long diatribe about alleged abusive process is disputed, and it's not worth the paper it's written on. It constitutes diversionary tactics which have no place in such proceedings. Well, of course they do when they are scandalous of the court and of your opponents. Then it says the letter marked FEL2 was unfortunately missed and will be responded to in due course. But then here, my Lord, the final paragraph. Suffice to state the obvious, that neither Mr. Zuma nor Dr. Schlorpe are part of communications. The statements are always attributed to their authors. The witch hunt is therefore misplaced and misdirected. What there is not, my Lord, is this paragraph consistent with what the Constitutional Court had said against at least one of the applicants, distancing themselves from the statement. Nothing there. So, my Lord,
your answering papers seem to suggest that the application should be dismissed toto as an abusive process.
No.
Now you're saying that this is relevant to costs.
It's relevant to costs as well as to the discretion that my Lord can exercise.
Yes. In relation to the declaratory.
Of course.
Yeah.
So it's in relation to declaratory, and it's, well, there are three places it's relevant. It's obviously costs, it's obviously declarator, all declarators are discretionary, and it's also in relation to the interdict, because my Lord knows the case law that an interdict, even considering all the other factors for an interdict, a court can always take into account the questions of abuse of process in deciding whether to grant it. So, my Lord, in those circumstances, we do ask for attorney and client costs, and the costs of two counsel. And I'm afraid to say I haven't read the luminous judgment about on the scale C, B, or A, but whatever the right scale is that
luminous or voluminous?
Luminous.
Oh. Might be voluminous as well, who knows? Yes, just on costs. You say that the attitude displayed to the full court's decision was scandalous and scandalous in the sense that it constituted a contempt.
Well, scandalous against...
Well, scandalizing the court is it a form of contempt?
Yes, Mr.
Yeah, I thought it was.
Yes.
You say that means a punitive costs order in this case should be made. That's the level of the submission, is it?
That is it, Lord. Lord, we're not seeking to hold anybody in contempt or asking my Lord to do so. But my Lord cannot ignore, you sit in the same judicial branch of government as the judges in that division. You know what the case is about. It's clear before you that this statement has been made by the same parties that are now saying this of the particular judgment. And my Lord, it's not that it was a scandalizing statement directed at the judges.
It was pretty clear it was about all judges, wasn't
Absolutely.
it? Yeah.
Blatantly political judgment of this court in respect of
I just worry
the
about
judiciary as a whole.
I just worry about deciding to attach penal consequences. Sorry.
We're not asking for quite that, my Lord.
Just forget that word. I worry about attaching punitive, that was the word I was groping for, consequences to an exercise of expression that may or may not constitute contempt of court outside the context of a contempt of court application. This is a highly political case where the applicants are deeply frustrated, I think would be an appropriate word, that the person they chose to sit on the JSC has been temporarily stopped from doing so. And they set this case up as a clash between those democratic rights and the Western Cape, well, the full court's decision to limit them, albeit temporarily, in terms of its decision. So against that background, there's a political ferment. And it's in that context that the press release was made. Now, the press release may well be contemptuous. It's certainly extremely strident. And Dr. Hlophe and Mr. Zuma may well, on the Constitutional Court's decision, be contemptuous in failing to disassociate themselves from it if they ultimately do. Ought that not to be the focus of a much more careful inquiry at the appropriate stage? I've had this case for 48 hours, and I'm being asked by you to say, well, I'm going to make a punitive costs order against Dr. Hlophe and against a party which is the official opposition in the National Assembly, largely because they said some nasty things in a press statement. That may well be turn out to have been unlawful and contemptuous, but there is a difficult underlying question there about the barrier between contempt of court, the exercise of free expression in a political context. Must I determine those issues in this case?
My lord, we would say with great respect, yes. First is it's before you. And you've got the evidence that has been asked of Dr. Hlophe, and then by the letters and the response that I've taken you to. So, my lord, you've got the evidence, one. Two, you've got the Constitutional Court authority in exactly the same situation. And in that case, my lord, I want to double check the authority. I will, while my learned friend is arguing. I recall that that was one of the reasons why the Constitutional Court said, not because of contempt of court, but because of that statement, that the court was going to, also as a court of first and final instance, by the way, issue punitive costs.
Yes.
And my lord, the third thing is that it's not only the political nature of the context. Political contestation is always heated nowadays. It's the question of what is said about the courts and about your opponents. About the courts, it's not just the judge in question or the judges, it's the judiciary. But then about your opponents, they are racists, they're masquerading, white malocchia.
Yes, I don't want to be understood in any way as condoning those remarks. I don't. On the face of them, they seem to be well, it would have been better if they weren't made. But the question before me isn't whether those remarks are good or bad. The question is whether particular legal consequences should be attached to them in the context of these proceedings.
Yes.
Yeah, and I think you've made your submissions.
I've made my submission. I'll finish by saying this. My lord has always, in every case, got to decide the issue of costs.
No, absolutely.
But these are the factors that go into the mix for my lord.
But the ordinary costs decision is much easier, normally. It's who won, was a constitutional issue raised, or has anybody misconducted themselves before me? Those are the usual costs inquiries. What you're asking me to do is take into account something at the periphery at best of that, perhaps even beyond that periphery, that involves penalising someone for the exercise of free speech, potentially. Perhaps it will be appropriate in due course for whoever was responsible for that statement and whoever failed to disassociate themselves from it to be appropriately penalised. I just wonder whether it's something that's appropriate to take into account at this stage.
Well, my lord, we've made our submissions.
Yes, and all I'm doing is opening my mind to you, just in case you want to try and change it a bit more.
I've given you my arguments as trenchantly as I could, and we stand by them.
Yeah.
Thank you. Thank you.
Mr.
Ngolwana, is Mr. Ngolwana going to reply first, or are you?
My lord, no, but if you can just make a request, Mr. Ngolwana may or may not address the court, but Mr. Ngolwana has asked me to make a request for a 5-minute break, and I'm conveying it because I might be the beneficiary of whatever he wants to decide.
Right, okay. Well, Mr. Duplessis was well within time. So literally a 5-minute break, 2:45.
Literally.
Yeah.
Thank you. That's correct.
Thank you.
But
You're going to name that. You're going to name your code after 5 minutes.
The most argument you get is on the scale of costs.
I thought that was it's sort of like I may grant the clarity
Yeah.
parallel in the JSC, but I don't think I can get into it.
But that was the thing he's most concerned about.
Yeah.
Hello. Bernadette Wex from News 24. Hi, I just wanted to ask if possible if I could have a copy of your heads, if there was one available. Or an email.
So,
what's your
so sorry. I need to know you're gonna take your bike for the meeting.
Yeah.
After he's back. Yeah, fine. So can you just do me a favor? Please take this also. Actually, I think we must separate it. No. This one.
Sorry, not email. Give me your number back and WhatsApp.
If you take this one only, paste it on. Just Ganji, just like this.
Bernadette.
Yeah.
Yeah, Wex.
Yeah. Okay. Muscle
Yeah.
It's okay. It's this one. It's this one. Yeah. Okay.
Thank you so much.
Okay. Sure. Hey guys, thank you so much for helping us there. Go and cut inside.
Yeah, but
How are you? I'm here the whole time. Oh, I didn't see you.
Bernadette. Doesn't want to go through on WhatsApp. Let me try you. But spell your surname. I mean, spell your email.
WOL, sorry, think about it.
RAWOL.
HUTER. Yeah, at gmail.com.
I don't understand how that's spelled Bernadette.
It's still in my maiden name.
Okay, good.
Yeah, looking good. What's the reference? 61. Max? Okay, no, but let me tell Max. Max? So, can I just say one word? The one catch you by surprise. In fact, I'm happy because I'm not the only one. We responded to that letter. Obviously, we are not aware. I'm sure you would have brought it to his attention.
You didn't put it in the affidavit?
No, we did. It was subsequent. But what you don't know, for obvious reasons, because it was probably 2 a.m. or whatever, is that we actually did respond. So I'm just going to tell you.
You received, sorry.
Okay.
I'm sure you did, but
Yeah. No, but I mean, obviously, like, I hadn't seen yours, so I can't blame you. I only became aware of yours when I saw your affidavit. It's because it was a mad weekend. But anyway, look, I don't think it's good. Did you upload it? But I'll ask my team what to say.
No, I'm sure this. That's fine.
That's fine. No, as I say, it's the same. I can't blame him because we literally had this and it was sent to me. But this man, I would say. So that's what the other was talking. Now he said literally 5 minutes and he's not here.
Takes a long time to make tea.
Yes. Especially on a Friday afternoon. He might be taking something strong.
If you need that job again, I mean, assume we finish it. I need to get to Victoria. I'm stuck there.
You're stuck on a Friday. Budget more than an hour. Because yeah, stay and rather than yeah, absolutely. It's the worst thing. Anything between on a normal day between 3:45 and so on, but on a Friday it's even worse. I think it starts even earlier.
No, I've got a hard copy.
You know the worst thing is last week I got my common sense because I always, you know, when you go to, in the morning it's all nice, and when you come back from court it's also nice. Then last week I had to go to the graduate business school or whatever. And I thought I'm going to Unisa University. Then somewhere on the way I looked at this thing, I know it's in Midland. So I got myself into that other craft. Coming this way. I always, I'm so impatient. If I was one of these people who are working to open, I would do that. I'm in the show and go
I just, my feeling is you've got, like Cape Town's bad, but they don't understand this is properly bad. Cape Town's just 50 minutes, then they get upset.
And the West is about half an hour in the morning when you're going into town from the airport. But after that, yeah. But yeah. That's why we know, like I come from East London. So what they call peak hour there is you think like 20 cars or 20 minutes.
German people get very upset if they put their car from the train.
Yeah.
It's a bad day. God's a big smile.
Yeah, I remember my granny used to growing up, I used to think it was like a journey where 7 minutes from the way my family spoke about it. Like a
Pardon? Do you want to start? You can start this. Did you get the references? I asked you guys for references. Yeah, but tell me. Just a minute. Do you have a pen? Okay, just a minute. I found one.
Our letter of the JSC.
Yes. It's at 0-123.
So you're saying this letter is okay? Wait, can I get? Let me get like a key. So this is
The letter to the JSC. It's at and it's at.
Just a minute. So is it at Christmas?
It's case we were parking. So everything's appropriate. And if you go for this one, you might
Anaksha? Letter 2. This is the letter 2, no?
Yeah, the letter of my 02-1.
Dash.
Some poetry have you negotiated?
We have a lot and I won.
So are you going to take all of the time? Or?
Yes.
Right.
Well, not all, but I've got it. It's not a target, but at least
Yeah.
I've got
Mr. Let's be precise about this. Mr. Ongolwana has ceded his time
Yes,
to you.
that's correct.
You
May or
don't
may
plan on taking all
Absolutely
of it.
not,
Okay.
no, no.
Right.
Yes.
Thank you.
Yeah. Thank you, my lord. My lord, before I do start, if I may just clarify something, shall we call it peripheral defamation? My lord, the Mr. Duplessis was obviously not aware, just as I was not aware of his letter, that we did respond to that letter. And I was going to read it into the record, but my lord, it's just been uploaded, if your lordship will accept it. And
Yeah.
it's at 02-62. It's just to say that there was a response. It's whether it's a good
62.
at 02-62, my lord, yes.
0262. 262.
Oh, yes. 02 dash.
Oh well, no, it's that I have something labeled correspondence here at 02-60.
60 to 62. That's correct.
Yes.
Yes, my lord. Yes. And I'm not going to belabor the point, my lord, simply to say, because to the extent that the accusation is that there was a non-response, which might suggest like nonchalant behavior.
Yes, this is what's referred to in reply, isn't it?
In a way, it's
Well, you say it fell through the cracks. We will respond in due course.
Yes.
And this is the response.
Take instructions.
This is effectively a response
Yes.
saying we will respond in
Yes,
due
yes,
course.
yes.
Yeah.
All I'm saying, my lord, is that it's not what it might look like was that, look, you just take it and throw it in the dustbin. That's not what happened.
No.
And Mr. Duplessis, my learned friend, was not aware of that response. No. Obviously, he would have brought it to the court's attention.
Thank you.
Thank you, my lord. Okay. Now, my lord, well, I suppose I must first be indebted, before I'm indebted to your lordship, to be indebted to Mr. Ngalwana, because his approach, my lord, is going to allow me just to do a little bit of an extra, hopefully 10 minutes to situate the case. Because with the greatest respect, my lord, and I'm not saying this flippantly, nothing that I have heard from my learned friends, all of them, suggest that my remark in the morning that we are at cross purposes, and I'm prepared to take some responsibility for that. Maybe we didn't clarify what this case is about. My lord, let me start here. It is the duty of a court, any court in South Africa, shall we say, to prevent and avoid the denial of human rights. Goes without saying, none of my learned friends can quibble with that. And that's the only reason we're here, my lord. Well, we might be right, we might be wrong, that's a different matter. But all we're here for, my lord, and nothing else, is to say, court, my human rights have been violated, and court, because you are the only person who can intervene, save for me going to self-help.
Yes, please don't do that.
No, thank you, my lord, I promise.
Yes.
You are the only person who can intervene one way or the other, and the court will say yes or no, as courts always do. Yeah. But really, that's all there is to it. And in crafting that plea to the court to intervene because our human rights are being allegedly violated, we then say, my lord, the manner in which those rights are violated manifest themselves twofold. In the first instance, they manifest themselves by a violation of the rights in the Bill of Rights. And I don't want to go through the list. I said section 1C, yes. 9, 10, 34. Yes. I'll just stop at that. If we are right about that, then we are entitled to relief in terms of section 38 of the Constitution. And it ends there. And we are also entitled to appropriate relief. That's all. And Section 38 is so lenient that it says if you have a right violated or even threatened to be violated. So even if we came here, my Lord, and we said, look, we're not sure if our right is violated of Section 19, but it's threatened to be violated, the Lordship would still give us appropriate relief. So let's close that chapter. That's the Section 38 case.
Yeah.
We then go further. We say, my Lord, assume that none of our Bill of Rights have been violated. But there has been an irrationality, which, as your Lordship said earlier, is 1C, not chapter 2, chapter 1 now of the Constitution. 1C, and we say there's been other violations, there may be all over the Constitution. And if we're right on that, that's the irrationality decision thing, then your Lordship must come to our rescue, but this time in terms of 172(1)(a). Right. And then we say, my Lord, if your Lordship cannot find, if your Lordship says no, neither your Bill of Rights have been violated, nor your other constitutional rights, then we say the court, nevertheless, on the Van Warmelo test, the court is still capable of giving us 172(1)(b) relief. I won't develop it. I did that in the morning. Now, my Lord, that's all, and we may be right, we may be wrong. We're prepared to accept that. But our case must not be mischaracterized as something else. And our case is not, I repeat, not to second guess, attack, criticize, backdoor appeal and so on the decision of the Western Cape High Court. But your Lordship, in a way, took the words from my mouth. But just as we, my Lord, cannot say that that judgment is wrong, just merely because it's on appeal, my learned friends also cannot say it's right. So what we accept is what your Lordship correctly beautifully put as the fact of the judgment, that nobody can wish away. It is there, and it must be taken at face value. The other thing that is true about that judgment is what your Lordship said to my learned friend, Mr. Duplessis, which is that in its interpretation, and that's the Firestone cases, Gentoo, Kuro, and so on. All the cases we've listed, SOS, Constitutional Court. In its interpretation, you have to look at the order and you have to look at the reasons. That's the trite. So your Lordship can't just say, I'm looking at this order, it says you must wait until the end of the Constitutional Court, and that's it. The Lordship will have to, is bound to on the Endumeni test to go to the reasons that are given and to interpret the judgment. And quite frankly, my Lord, it doesn't matter at all what was argued in Cape Town by either the DA or ourselves or whatever. The test is objective. So the DA might have gone to court to look for 3 cars, but the judgment is about 1 car. All of that is irrelevant. Your Lordship is guided by the objective wording of the thing, the context, the usual Endumeni things, and to interpret that judgment. Now, so when Mr. Ngalwana says, look at the judgment, it says MPs, and it says 1 designation, and it says the designation, my word, is indivisible. Then that's it. It doesn't matter that the DA went there only to hunt for Dr. Hlophe or whatever. But if the judgment came out that way, it came out that way. Of course, Mr. Maneche is also correct to say that there may well be some other readings, such as paragraph 56, where they say, oh, well, the other 5 will be there and so on, which go the other way around. That's fine. I'm prepared to do that. But Your Lordship, both on Mr. Manecha's pinpointing of certain paragraphs and Mr. Ngalwana's pinpointing of certain paragraphs, must objectively, yourself, my Lord, say that this is what the impact of the judgment is. So I just wanted to clarify that. Now, and it's not about the correctness of the judgment either. Now, there's another small red herring that was used here. My learned friend, Mr. Duplessis, I think. Oh, no. Let me stick to this. My learned friend, Mr. Manecha, says correctly, assuming for now he's right on the Section 18 discussion. He says, and it's quite correct, that there were parties in the Western Cape High Court, but not in the Constitutional Court, where they were not cited. But all my learned friends make the same mistake. So they say, well, that judgment is binding on the JSC. Of course it is. It's binding on me as well. But that's not the question before Your Lordship. The question is this, and everyone is eliding this question. The mere fact that there is a binding judgment on the whole world does not mean the JSC is forced to do something. Let me repeat that. The mere fact that there is a judgment of the Western Cape that's the non sequitur. Does not mean that the JSC must decline the postponement request. So it's not bound in that sense. The Western Cape judgment never said the JSC must decline the postponement request. Or put differently, if the JSC granted the postponement request, it would not be breaching the Western Cape judgment.
Yes, you accept the way I put it to Mr. Duplessis was there are 2 ways to comply.
Absolutely.
One is to continue without Dr. Chlorpe, and
yes.
One is to not continue
absolutely.
Until Dr. Chlorpe can participate. And the yes. question is whether the JSC's decision to continue without him is rational.
100%, yeah. Lord. So, but the way it's being formulated in this court is as if the existence of the Western Cape judgment means that the JSC's hands were tied vis-a-vis the postponement. No. The JSC, while complying with that judgment, could have said, yes, we're going to... Nobody would have said, you're in breach, you must go into contempt, go to jail, and so on.
I mean, that's obvious because, as I understand it, minority of the committee of the JSC that made the decision.
Yes.
So
absolutely.
We should persuade.
100%.
But they should persuade.
Yes. And no. Absolutely, my Lord.
It clearly has to be approached on the basis of the fact of the judgment and the rationality of the JSC's response to it.
That's all. And Your Lordship, no, I won't belabor the point. Your Lordship has hit it. The mere fact that some of the members of the JSC said, let's postpone, doesn't mean that they were in contempt. They just were outnumbered. But there's no right or wrong. Yeah, all right. No, then it's clear, my Lord. So let's get that red herring of being bound, quote unquote, out of the way. So to give, and that's what we mean by material error of law. So for the JSC to think that they were bound in the literal sense, that they had no option but to refuse the postponement, or to give that as a reason, is itself a material error of law.
Does that interpretation arise from its letter?
From its letter, yes. So the preamble, not the 2.1, before 2.1, just the preamble.
Considers itself bound by the judgment.
Yes. So that's where that once you made that big material error, everything goes south, because you are thinking that you are bound in the literal sense. Now, my Lord, the funny thing is this. You remember that in the JSC's answer, they say we, What we are missing is that they had a discretion, and they exercised the discretion, and I agree with them, by the way. They exercised that discretion just as, it's funny how these arguments turn around. When we said in the Western Cape judgment, of course the National Assembly had a discretion to whether to designate or not designate. That's why they put it to the vote. That's exactly what the JSC did correctly. They would, if they thought they didn't have a discretion, they wouldn't have put it to the vote. They would have just said, we don't know what these people are smoking. And we obviously can't do this, and so on. But the mere fact that they put it to the vote means that they had a discretion. Mm. But in the same breath, they're telling you they didn't have a discretion because they were bound by the Western Cape High Court decision. So it's just a mishmash of irrationality. Now,
well, I mean, you've got to interpret the letter as a whole, haven't you?
My lord?
You've got to interpret the letter as a whole.
Yes, of course, of course. No, but I'm just dealing, yes, no, fair enough, my lord. Yeah. But I'm dealing it the way Mr. Manager dealt with it, that effectively there are three reasons. Yeah, the first one is that they are bound. Yeah. The second one is the one that I'm going into now. Yeah. So then, my lord, here's this one takes the cake. So they say, well, MK in their letter, in their own letter, say that they're not sure whether it's 18.1 or 18.2 and so on, and it may or may not be binding. What have you? You heard all the submissions. But they forget one thing. You know, people sometimes make elementary mistake. All they need to do, not to make that absurd suggestion, is to look at the date. That's all. That's all. The date of that...
Does it really matter what the MK thought and when it thought it? The question is objective.
Absolutely. Firstly, it doesn't... exactly, my lord. Even if MK said, we are bound, it would be... the law is the law. That's the first point, my lord. Yeah. But the second point, which is even more important, is that at that point, the application for leave to appeal had not yet been served. Yeah. So... But all my learned friends argue this matter as if those applications had already been served. So at that point, theoretically, and I'm saying this very theoretically because it could not have happened. Theoretically, MK could have even said, no, we've decided no longer to appeal or whatever. I'm just using it theoretically. But as it happened, once they then lodged their application for leave to appeal, then Section 18.1 triggered itself on our version, or 18.2 on their version. That your lordship will decide that. But nobody must come here and say that in your own letter you don't say, because that letter precedes the filing of the... Okay, so at least let's get that out of the way as well. If your lordship goes to 02132,
yeah.
You'll see two things, Mel.
The application for leave to appeal.
Sorry, okay, mine seems to be in a different place. 02? Yeah. Okay, I've got it on a different place, my lord. But, and I don't want to waste it.
At 02-132.
132.
I have an application for leave to appeal. Is that what you want to take it for?
Okay, then my numbering is wrong. Okay, so I'll just use the natural numbers.
Give me the document and the paragraph number.
Yes, okay, my lord. It's an annexure to our notice of motion, I think. Yeah. Yeah, I don't. Oh yes. Okay, it's in the wrong place, so I'll just refer to it to. So on at paragraph. Let's start with the face of that. On mine is on 0285 for some reason. So it says notice of urgent application for leave to appeal.
Oh, right, yes, no, that's
Yes,
what I have.
that's the one, yes. And then it says the usual take notice and so on and so on. And then further it says, and this is now, remember the subsequent, take notice further that the said decision, which has final effect on MK and or Dr. Hlophe, will be appealed on the grounds set below. And that's the issue. So again, that might be right or wrong legally, that's not the point. But the appeal is brought on the basis that that decision has final effect on MK and or Dr. Hlophe. In other words, it's a Section 18(1) situation. That's, I just wanted to point that out. So there is no world in which the MK was now, having said its final and effect, bring an 18(2) application.
No.
Yes, because it was effectively saying we're bringing this. In fact, those words, it might as well have said we're bringing this under Section 18(1). That's what it means. Yeah. So that's the other red herring out of the way. Then, my lord, I agree with one of my learned friends, I think it's Mr. Bishop, that there is usually a confusion, and this debate is very complicated. It looks easy about 18(2) and interlocutory and final effect, Zweni, and so on. But there's always a confusion between the issue of appealability, which is one thing, and the application of 18(2). Those two things are not the same, contrary to popular belief. And I'll illustrate why they're not the same. Appealability is implied in 18(2). And because we didn't need 18(2) if as Mr. Bishop says, all interlocutory orders were not appealable.
It's not even about that. It's about what happens when a party applies for leave to appeal against any order.
Absolutely.
Whether it's appealable or not.
Is another
whether
question.
It's final
Absolutely.
or not.
Exactly.
And the question is, what immediate factual effect does the application for leave to appeal have?
Absolutely.
If the order is an interlocutory order not having final effect, it's not suspended.
Yes.
If it's an interlocutory order having final effect,
it's suspended.
It's suspended.
Simple.
If it's a final order that doesn't pretend to be interlocutory,
there's no debate.
Yeah.
Yes.
So I don't think that we need to sort of delve too deeply into the theoretical debates about appealability and finality.
Yes.
It's fairly clear to me.
But it's important only in this respect, Madam.
Yeah.
If we are correct that one of can't remember which of my learned friends say interim orders are always non-appealable. That's not true. Even interlocutory orders, that the point I'm making, that even pure interlocutory orders, if they were always not appealable, then why would we have something called 18(2)? Because that postulates an appeal. I think
that was Mr. Bishop. He said, in almost all cases, interim interdict
always. He used the word always.
Are not appealable, but that where they have final effect, they are.
Absolutely. Thank you, my lord. I'll move on. Yes, I'll move on. Then my learned friend, Mr. Manager, gives me what we call a backhanded compliment, because in the Moyo case, we succeeded to distinguish between 18(1) and 18(2).
Yeah.
And for a change, the other side's argument was described as farcical. But that's a non-example, because in Moyo, it was exactly this debate, and we went into CIPLA and all those cases about appealability. So the issue in Moyo was appealability, not what we're debating here today.
Yeah.
And as it happened, that victory that Mr. Manager was attributing to me was on the question of appealability short-lived, because as everyone knows, within a few months of that, the appeal happened, and it was actually reversed. And we even tried to go to the SCA on the basis that we should not have lost that appeal because it's not appealable, and the SCA said no. So that just shows that this thing is a slippery issue. Right. Then, my lord, there's another, this popular paragraph 56 that everyone is misreading. Paragraph 56 of the judgment says the respondent's submission that the JSC would not have a quorum in order to take valid decision if Dr. Tlhopre is not deterred from participating in that forum is incorrect. And then it goes on. Later I'll just read the part that Mr. Manager said I didn't read, and to show that it actually assists us. One of my learned friends said that is I think it was Mr. Bishop. I think Mr. Bishop is was being creative, to put it mildly. He said that this was a linguistic error. Yeah. But you see, you can't have it both ways. You can't say the judgment of the Western Cape, we must take it at face value when it suits you. But when it doesn't suit you, you point to a so-called linguistic error. There's no linguistic error, or if there is, it will be resolved in the appeal.
Yeah.
But for the purposes of your lordship, that paragraph deals with quorum. It does not deal with composition. It doesn't deal with Mr. Bishop, so that I can buy his favor now. Also correctly listed.
Is it for sale, Mr. Bishop?
Yeah, it is for sale. You only have one leg to stand on. And Mr. Bishop gave a list. He even increased my list. He said there's the issue of composition, which is true. Yeah. There's the issue of quorum. And then he included, there's another issue of attendance. Yeah. And Mr. Bishop is obviously correct. And that's why he had to find the linguistic error trick. Yeah. Because those three things are completely separate. The point of the matter is that even assuming, which we have to, that paragraph 56 is correct, it only deals with quorum. It doesn't deal with absence. It doesn't deal with composition. Yeah. And it certainly doesn't deal with what is called in the Bar Council case, the delicate balance that is sought to be struck by the Constitution in constructing, in designing, I think is the word they used, the JSC. Move on. Then, all my learned friends, no, this is Mr. Bishop again. Yeah. Okay, I'm also going to be in his bad books again. He says that the DA says about the other 5 people, no, we like them. That includes Mr. Malema. So we'll take that with a bit of pinch of salt here. But in that formulation, my lord, what the DA is doing, on a more serious note, is mixing up the issue of the remedy and the declarator. Because of course, my lord, I cannot stand here and say to your lordship, when it comes to remedy, your lordship must not take into account all these things. Is the sky going to fall and all that? I can't. Because when it comes to remedy, your lordship must do that. But when it comes to the declarator, your lordship does not have that option, because the constitutional writers took it away from your lordship by using the word must. So all the Mr. Ngaitobi considerations and so on, of course, they'll be relevant in the discretionary part of the thing, but they're not relevant for the declarator. And this might even be an argument against myself, but I have to make it in fairness. I accept, my lord, implicitly, that, I think it was Mr. Bishop, that the likelihood is that the sky is not going to fall. Because courts, either way, by the way, there's no sky that's going to fall. Your lordship simply has to weigh the balance of convenience. And I'll make 2 illustrations. One, it is that there's been a vacancy, I think, in the Constitutional Court for 4 years, and the sky has not fallen. So if the vacancies are not filled in 2 or 3 months or whatever, the sky is not going to fall. But against me is the same argument. The sky is not necessarily going to fall if there are, let's call them invalid appointments. Because your Lordship and everyone here knows that in the so-called NTPP cases, the courts under Section 172(1) always fashion a remedy, which says, I think the Simelane case on Ngasana and so on, it always says, okay, this appointment was invalid. But for good governance, you can't say this NTPP is invalid. Therefore, all the criminals who have been prosecuted in the last 6 months can walk free. Nobody does that here. So the court will always accommodate those sky-falling things and deal with them in terms of 172(1)(b). Then, my Lord, so I'm just trying to go to the. Oh yes. I don't intend to give a lecture on this, but I have to say this. If the law is very simple, if we are right that there's a prima facie or threatened right, Section 19 or whatever, then all your Lordship has to do is to do what is known as a limitation analysis. So your Lordship will have to say, okay, your right to participate in the forthcoming interviews translates into your right to participate in the political activities of your choice, Section 19. So prima facie, it will be limited. And that's all that is needed, my Lord. Limited. That word was chosen deliberately in Section 36. All we need to show, my Lord, is that that right will be limited. And it says in this book of Carré and Duval, I don't know if it's the latest edition. Limitation, page 151. Limitation is a synonym for infringement or perhaps justifiable infringement. And here's the important part. It says a law. So even the court order, let's call that a law. A law that limits a right infringes the right. Let me read that again. A law that limits the right infringes the right. So a court order that limits the right infringes the right. So you can't have a circuitous argument that says, no, it's justified because it's a court order or a statute or a whatever. Because if it limits the right, it limits the right. And then it says, however, the infringement will not be unconstitutional if it takes place for a reason that is accepted as a justification for infringing rights in an open democratic society based on human dignity, equality, and so on. And where an infringement can be justified in accordance with the criteria in Section 36, it will be constitutionally valid. Then I'm jumping to the bottom. If rights can be overridden simply on the basis that the general welfare, which is what we're told here, will be served by the restriction, then there's little purpose in the constitutional entrenchment of rights. Yeah. So all these big stories were told, oh no, the judges or the burden of the courts are going to all crumble. The general welfare, they say if you were to take those into account, then what's the point of having entrenched rights? And then said, but however important the purpose of the limitation, restrictions on rights will not be justifiable unless there's a good reason for thinking that the restriction would achieve the purpose it is designed to achieve, and that there is no other realistically available way in which the purpose can be achieved without restricting rights. In other words, to bring it home, we'll have to show that there's no other realistic way, such as the postponement that you are proposing, in which you could avoid the limitation of rights. And our case is that there is. Now, here's another one, Melon. We are now being beaten up for being realistic. So my learned friends say, well, you should have then just come to say, no, we want Dr. Hlope to be there on Monday. Of course, we could have done that. But how can we be punished for doing that which is responsible citizenship? where we're saying, we may be right, Dr. Klopper might be entitled to go there on Monday. But no, we don't want to take that option. We're saying, let's all hang tight until there's clarity. And now Marlene Friend says, you know, well, you should have demanded that we're going on Monday, or walk in, or do a sit-in, or I don't know, whatever. But the only thing we're asking is for rationality. And we're saying, given the shortness of time, the fact that we cannot do, even if we were to do a Section 18, neither us nor you can do a Section 18 in 4 days. Parliament is in recess. The meeting is next Monday. It's not a creation of our own that the judgment was only given on Friday. We are all been put in this situation. Given all that, let us take a via media of pausing and making sure that nobody's rights are infringed or limited. And then they say, no, you should have gone for the jugular and cut our necks. We don't want to. You can't force us to do something, because we are mindful of these issues, my lord. It might well be, what if Dr. Klopper goes there on Monday, possibly or otherwise, and then a week later there's Part B, which says he should not have been there, as we've said. Then you have the flip side of the problem. So all we're saying is, no one must be put in that situation. If Dr. Klopper is right, don't prejudice him by permanently removing him. And by the way, this thing of final effect must be addressed. It might look on a piece of paper as an interim or permanent or temporary setback. But the reality is that, and that's what we mean when we say it has final effect on MK and Dr. Klopper. If the meeting continues without Dr. Klopper, it is irrecoverable and irreversible that he would have been deprived of participating in those interviews. So it's final in effect in that sense. Similarly, MK's, I was about to say bragging points, but it's more serious than that. MK's right to have its member sitting in these interviews would have been permanently and irreversibly, till thy kingdom come, have been...
That's right to have that particular member.
Absolutely.
Yeah.
Yes. So that's what we mean by final in effect. And we're talking about human rights here. We're not talking about some frivolous thing. So if you deny or limit, I prefer that word for obvious purposes. Yeah. If you limit that right even to that extent, that has a permanent and everlasting effect. Then, my lord, on a lighter note, we were told that Mr. Trenkov made a transient submission, and Marlene corrected himself that when he said it was cogent. It was obviously not cogent because he lost the point. Yeah. And that point was this: Mr. Trenkov's client FUL and Mr. du Plessis, for that matter, was saying that they should be given final relief alongside the interim relief, and the court, in a balancing act, found against them and said no, we'd rather postpone that to Part B. So that's that's what happened. So that and then, my lord, we're also told that, but against Mr. Ngalwana, it is said that you have not challenged the other 5. But we've said this in our, I know your Lordship hasn't read our reply, but when your Lordship does, we'll make the following point. And I can say this from the bar, I hope, unless my learned friends object. We do hold instructions, my lord, to challenge the other 5, if you like. And the only way we can do it, and because one of my learned friends, I think Mr. du Plessis, correctly analyzed the situation in his affidavit. What we do, my lord, is what is called a conditional counter-application. Because obviously, and one of my learned friends was correct to say that you can't blow hot and cold. So what we're going to say is to say, if we are wrong on the Ngalwana argument, then conditionally, then the other 5 are also tainted. But here's the point. You can't do that now. You can only do that when we answer to Part B. Because we'll do the conditional counter application as part of that. We're still far from that. They have not even done the supplementary affidavit in terms of Rule 53 and all that jazz. So when all that happens, we will then do the Rule 53. And as I say, even from the bar, we will then attack that that issue. So you can't criticize us now. How are we going to do it? Let's say we wanted to attack it. We can't. It's too early. If you want to criticize us, just wait until you get our answering affidavit. Then, my Lord, I'm coming towards the end.
Yes.
Your Lordship really hit the nail on the head. Now, before we do that, let's go to Mr. Bishop. Mr. Bishop cites the case. There's some the case of the public protector. It's some case here in which I was gratuitously insulted. Now, that case, my Lord, is not authority for the proposition that Mr. Bishop says it is. That case, what happened in that case is that in the, actually that case works against him. In the High Court, in the full court in the Western Cape, the public protector said, there's been bias and all sorts of things. Somebody's husband was judging me and all that. and it should be reviewed on that basis. The court, in our respectful submission, wrongly, and I say that boldly because that process, that case is still in the appeal pipeline, so to speak. So it may be confirmed or not confirmed. And that's another reason why Mr. Bishop may not rely on it. I can put every cent I have that that case is going to be appealed, if nothing else, because the client is aggrieved. Me, I'm fine. So what that court said, it said it's in medias res, because the Section 194 thing is still running. But the court did something which, and I don't want to criticize the court gratuitously and do the opposite. The court did something that should not be done, which, imagine if your Lordship said this, I'm not going to give you the declarator, and that's it. And therefore, I'm not going to look at prayer 3. That's what that court did. So it was blatantly wrong, because it said, it's in medias res, and therefore we're not going, and Paja doesn't apply. Therefore, we're not going to look at legality, which is bizarre. But that court was not authority for the proposition that a decision, which Mr. Maneche, to his credit, has never said that it's not a decision, because it is. A decision is somehow in medias res, or is not an administrative decision. Which, by the way, in case I forget at the end, deals also with the question of costs. I mean, this is the biggest irony. Mr. Maneche, who's my real opponent, says he's not looking for cost orders. And then some people who just came for a reason that we cannot understand. Yes, but on the basis that only if you oppose, I'm sorry, my Lord, I shouldn't be responding to the banter. Yes. but let me say this, my Lord. The reason why, paragraph whatever it is of our founding affidavit says exactly that from number 2 to number 22, they are only cited of any interest they might have, but no relief is sought against them. That's the point. So the only relief that was sought was against Mr. Maneche. I know they were cited because I'm the one who cited them. But the point is that what is the DA and FUL? Why? What is their business about whether there should be a postponement or not a postponement? They said in Cape Town they were protecting the rule of law, fine. And
I think their view is the rule of law is best protected by the JSC proceeding without Dr. Klorpe.
Aha.
Might be right, might be wrong, but that's why they're here.
Exactly. But that's exactly, remember the shoe is now on the other foot.
Yeah.
We are also here now to say exactly that, my lord. We're here to say the rule of law, rationality, will be best served by reading the letter of reasons of the JSC, and on its assessment, make declaring it to be irrational. That's exactly. So the only reason we're here is of course to protect the rights of the principal parties. But the broader reason, which is why 172(1)A applies, is because we're here to protect that rule of law. So they can't say, when it was their turn, rule of law, and then now, when the Dr. Klorpe and MK say, well, the rule of law says that we should postpone, then they say, no, go forge ahead, break the rule of law. Now, yes, I have to say this about Mr. Du Plessis so that Mr. Bishop doesn't think I'm only picking on him. Mr. Du Plessis' client misses the point, really, by a mile. Because their case is untenable. Their case, they say, the court has a discretion on the declarator. The court doesn't have a discretion on the declarator. They make that mistake because they miss the law. And you can see why they miss the law. They rely on Ogbay, on that case of Ogbay, the Gupta's case. That case, my lord, was not brought under Section 172(1)A or even Section 38. It was brought under Section 19C of the Superior Courts Act. In terms of Section 19C of the 19(1)C of the Superior Courts Act, of course, the court has a discretion to grant in what we call an ordinary declarator. But that's not what we're talking about here. In this case, we're talking about Section 172(1)A of the Constitution. So Ogbay has got nothing to do with what we're discussing here. And then yes, Your Lordship, to one of my learned friends said, and this is hopefully the last point, when I was saying Your Lordship hit the nail on the head, Your Lordship summarized it as follows, and I'm going to borrow the words from Hoekstra and Penfold. The relief that we seek has got two pathways. Can't remember the word Your Lordship used, but it's something to that effect. And these pathways must not be confused. Mr. Manecha, I'm picking on him now, makes the fundamental mistake of not appreciating the gravamen of the Hoover School van Warmelo case. Mr. Manecha says wrongly. It doesn't matter whether you are looking for the common law right or whether you're looking for the constitutional interdict. It's all the same test. You have to apply the same test. No. And the authority for that, my lord, is a case called EFF versus Godin. EFF versus Godin makes it clear, my lord, that there are three things. There's what we call the normal outer test. There's the Section 172(1)B van Hoover School Ermelo type. And then there's a third, even a third category, my lord, called suspension. So if you are if Your Lordship in your wide discretion can say, I'm not doing any of the things that Mr. Mpofu is asking me to do. So I'm not going to give you a common law interview, interdict, and the pun was not intended, interdicting the interviews. I'm not going to give you a common law interdict, And I'm also not even going to give you a whole school MLO relief. But I'm going to give you relief that says that the interviews are suspended, or suspend the decision, the non-postponement decision. And I'll show you, my lord, what impact that all has on the tests. If you go to EFF versus
it's the Constitutional Court decision.
Yes, the Constitutional Court, unanimous. There were two decisions. One was Khampepe, which was
everybody
unanimous.
Concurred.
Yes.
Each judge concurred in both.
Both of the, yes,
yeah.
both unanimous. Yes.
Yeah.
So if you go start at 108, my lord. It says when the High Court determined the first part of the application, it was exercising powers conferred on it by Section 172(1) of the Constitution. On the authority of our school Ermelo, the power to make a just and equitable order does not depend on first declaring law or conduct invalid. Considerations of justice and equity permeate every order made in constitutional matter. I say a lot more about this later. In other words, to paraphrase, the only test on a 172(1) basis is considerations of justice and equity. Is it just and equitable? And then he says at 109 chapter J, therefore the High Court erred and concluded that, which is what this court is being asked to do, that Part A of the application before this court does not constitute constitutional litigation. Okay, that's a different point. The fact that the interim interdict may be granted in non-constitutional litigation does not mean that if sought in constitutional litigation like review, it is not part of that litigation. Here's the important part. Earlier, and relying on the decision of this court in Outer, that's Mr. Mainecha's point, the High Court held that the purpose of the interdict was to protect rights yet to be determined. Then jump, my lord, to 110. The outer standard which the High Court embraced and applied is applicable to constitutional matters, and so on, what we all know. Then at 113, I think is the gist. Yeah. Says, therefore, even if it could be said that there were prospects of success against the grant of the interdict, the applicants for leave would still be faced with the question of whether there was prospects against suspension. In other words, whether the suspension of that, or I think it was a remedial action of the public protector or whatever in that matter. And here he says, requirements for suspension differ from those needed for an interim interdict. The outer standard does not apply to suspension. So even though we all know that a so-called suspension in effect is a prohibition, so it's an interdict by another name. Even though it would have the same effect, but to that relief, the outer test does not apply. And then that is for a reason. So Mr. Mainecha's thesis that it matters not whether you are in the land of 172(1)B or operational structural interdict or whatever, it all comes back to outer is wrong in law, according to the Constitutional Court. So your Lordship's mapping of the two pathways is therefore correct, which is to say simple. One pathway is declarator, 172(1)B or Section 38, gone. But if we are wrong on that, then the second pathway is, in fact, there are three pathways. The second pathway is Mr. Malona's approach. Common law, normal, outer, and all that, boom, gone. But the third pathway is your Lordship fashioning a relief such as a suspension, where your Lordship will not be then bound by the outer test and all that, but by the interests of justice and justice and equitability and weighing these. Where Mr. Mainecha might be right is that even in that exercise, obviously one has to look broadly because it is by its nature discretionary. But that's not the same thing as saying the outer test, you just plaster it around like that.
Yeah.
Thank you, my lord. I'm just checking if there's anything else, my lord.
Yes.
Okay, yes. My lord, I won't belabor this point. I implore your Lordship to just do a simple exercise and take our letter to the JSC on Monday and then take the letter that the JSC wrote to us on Tuesday. And I must commend the JSC for they actioned our letter. Within that evening, I'm told there was already a virtual meeting or whatever. And the Lordship must simply say this. You'll see in our letter, we even apologize. We say we apologize for the length of this letter because we wanted to avoid this kind of debate. That's why we went to town to say the Section 18 might happen, might not happen. Please, this is not about the quorum, it's about composition, and so on and so on. Because we didn't want, when people are sitting in that meeting, to be debating those trivialities. And wrote a very detailed letter. So if your Lordship takes that letter and see the spirit in which it was written, which is to say, let's avoid litigation, let's have a draw kind of situation where there's a truce. And then you see the response to that letter, which actually makes it clear that they did not read the letter, or if they read it, they didn't read it properly. Because then they come and do exactly what we said they mustn't do. They conflate quorum with composition, and then they invoke Section 18 in vain, which is what we had gone to town to make sure that they don't do. And we even sent, once the leave to appeal was out, we immediately sent it in the evening, I think an hour before their meeting. All this was for one purpose, so that they don't get waylaid into the wrong Section 18 wild goose chase, or the wrong Section 178 wild goose chase. But that's exactly what the JSC did, with the greatest respect, and ignored the via media that we were trying to say, and went gung-ho, no, we're bound, and no, it's 18.2, and no, he was not removed. And my Lord, this is the last submission on the SCA. Surely, Mr. Bishop cannot be serious that this court is bound by the full court interpretation of the SCA judgment. Because there's one of two things. Stare decisis doesn't work like that. If as Mr. Bishop, and I hope I'm not targeting the wrong person, if as my learned friend says, that all that the Lidwaba DJP and Sutherland DJP judgment did was to confirm the SCA judgment. That's scenario one. Then, of course, your Lordship is still bound by the SCA judgment more, because they have a binding effect. Obviously, two SCA judgments versus a full court judgment, the binding effect will lie with the two SCA judgments. If, on the other hand, that's scenario two, the High Court judgment contradicted the SCA judgment, then again, your Lordship is still bound by the SCA judgments until they are overturned, until there's another judgment that says the full court was right. So, whichever way you look at it, the judgments that are binding upon your Lordship are the two SCA judgments, and both of them say the same thing. They say the following: the general rule, and to his credit, Mr. Maneche accepted this. The general rule is that if the JSC is not sitting en banc, then it's invalid. That's the bottom line. However, it says, those courts say, and that's the thing about the justified exclusion. Yeah. Of course, as all legal rules have, they always have an exception. Of course, if there's a justified reason, then that general rule may be attenuated. We all accept that. But let's not confuse the court. The general rule is very, very simple. It comes from Ski Road. If there is a statutory board of directors, school board or whatever it is, which is prescribed to sit as a whole, then if it's not sitting as a whole, that decision is invalid. So the question before your Lordship is a narrow one, going to your Lordship's straight line example. It's very simple. is there a valid justification for the non-postponement decision of the JSC? There either is or there isn't. If, and nothing has been said to convince anyone in this court, least of all your lordship, that there is. And to do that, your lordship will have to go back to the exercise I asked your lordship to do. Take the 2 letters,
yeah,
and your lordship will see that none of those things listed there lends itself as a valid justification for the non-postponement decision. Least of all, the idea that because you are bound by a decision, therefore it means you must not postpone. And if we're correct in that alone, then the lordship must grant the declarator, and the rest I'll be repeating myself. So those are our submissions, my lord. Yes. As far as costs are concerned, our respectful submission, there was some contrivance about the fact that these people are working in Parliament and therefore they are public. I don't think that was seriously meant. So apart from the issue of the freedom of expression or no freedom of expression, which your lordship is correct, and let me speak for myself. I agree with your lordship. One cannot condone those remarks. But whether or whoever issued that statement or did not issue it or was part of it or knew about it and so on, that might be clarified in the appropriate inquiry, as your lordship said, not before your lordship. So apart from that, my lord, if there ever was a deserving case, it is this one, my lord. To actually say somebody whose fundamental rights in terms of Section 19 are being limited, infringed, violated, whichever word you like, must be punished for coming to court to say, court, please rescue me. I'm being closed off in sentence somewhere, and that act infringes MK's rights, and it also infringes Dr. Klope's rights. Rightly or wrongly, win or lose, to say that, to actually assert that is a punishable offense, my lord, is really gilding the lily and taking things too far. So, my lord, with the greatest respect, your lordship must, with the greatest respect, I say this with the greatest respect, find that the legal effect of the Cape Town order is to reduce the constitutionally ordained 50% threshold to 40%. And by doing that, ipso facto, what was said in paragraph 35 of Bar Council, the constitutional design is disturbed, and so on. And a court order cannot be allowed to do that, because it is the Constitution that is supreme, not the court. We respect the court. The court can give orders and so on, but no court can give an order that breaches the Constitution. If it does, obviously it's not doing it advertently. And if it does, then the court, this court now, it is the duty of this court to say that the legal effect of this, intended or not intended and so on, but the legal effect of this is to disturb the constitutional design. And I, as the court, will not allow it. And then I'll find some structural way which balances all the rights, what all my learned friends have said. And that's all we're asking your lordship to do, so that on Monday we don't have an illegality continuing in our town. Thank you.
May I ask for your leave just for half a minute?
No objection.
To deal with an issue that we could not have anticipated, which is the instructions
yes,
conveyed from the bar that there will be a challenge to the 5. The implications of that is that the promises of our learned friends that this, if there's going to be a postponement, is a 2 months or 3 months postponement, is really pie in the sky given all these challenges that are coming. Yeah. That's all we needed to draw that to your lordship's attention. Is the court pleases.
Sorry, my lord. I don't object, but I just have to say one sentence. That's not true. All my learned friends have missed everything. The reason we say, my lord, we give you 3 options for the, let's call it part B. My learned friends have all missed this. We say either you must await the application for leave to appeal, and we concede that it's not going to take 2 weeks. Might take 2 months, might take 3. Mr. Manager might be right, it might take 100 years. Okay? And then we say the second one is that Part B of the Western Cape Court must be entertained. Take 1,000 years, it might. But we say, or Part BB, whichever happens first. And we've demonstrated to your Lordship that Part BB, which is really the analysis of a letter, can never take more than. That's all we're saying. So we accept Mr. Manager's 20,000 years for the thing. But the way we formulated it was to make exactly sure that we ameliorate any harm that might eventuate as a by taking the lowest threshold, which is Part BB. Assume the courts won't give us expedited hearing. Assume we'll bring 1,000 counter applications, whatever you. But surely your Lordship knows that any JP will be able to case manage this thing such that it can be disposed of quickly. We're not making, so I'm not putting, I don't want one day to say you said 3 months or whatever. I'm simply saying this is not this whole thing that the sky is going to fall is 100 years and so on. It's something that can be limited, but in the best case scenario for them, it can only be pegged to Part BB, which, by the way, your Lordship said might even be rendered academic.
Yes.
And I agree with them.
Thank you.
That's God, please.
Yes. I propose to reserve judgment for a short while. I anticipate being able to give judgment during the course of tomorrow. I will circulate the judgment by email. My registrar has a list of all interested parties. I dare say that if members of the press present wish to receive the judgment more or less as it's handed down, if they send my registrar an email, he will accommodate you on his list. Mr. Mpofu, Mr. Mayaniche, that is sufficient to allow your clients to organize themselves in light of whatever I decide, is it?
Yes.
A judgment during the course of tomorrow.
Yes, I think it should, under the circumstances that.
Yes. So if, in other words, I say the JSC meeting can go ahead, I won't make that impossible by taking until tomorrow afternoon to say so.
Yes.
That's
yes, because of travel arrangements.
Yes.
And all that.
Yes. So if I decide the JSC can go ahead, to do so by tomorrow afternoon wouldn't create any problems.
I would assume, but I think my client would appreciate that that's most expedited
yes.
response from the judiciary.
Yes. I'm not going to give an order with reasons to follow.
Yes.
I'm not going to extemporize.
Yes.
And the fastest I can move in a case like this is just under 24 hours.
We would accept that.
Yes.
My Lord, similarly, my Lord, we accept that. In fact, just to give your Lordship the assurance, one of our options was to set this better time for Saturday, but we wanted to avoid exactly that.
Yes.
So the reason why it was done on Friday was so that anybody can make whatever arrangements my clients might want to make on either eventuality.
Yes.
We are in the same boat. We don't expect your Lordship to do miracles.
And presumably no difficulty from full or the DA's perspective.
None, my Lord. None, my Lord.
Very well. Judgment is reserved for a short time. Thank you all for your assistance. Thank you all for more or less keeping to time. The court will adjourn.
And that's it.